May I please, Your Lordship, my prayer is for listing, Lordship.
Listing it, not this one.
Sorry, Lordship, sorry.
Item 1 for orders.
My lord, I beg to mention item number 18, my lord.
My lord, in this case, there was no objection to the condonation, well, delay, my lord. So condonation petition was filed and that has been earlier allowed. So, my lord, now matter may be taken on the merits, my lord. Majida Khatun. 14/3/2023. IA 2742/2022.
Delay had already been condoned.
Condoned. So matter may be taken.
So now
you
you
proceed.
want to argue today?
Yes, my lord. Yes, my lord. Here, my lord, Lordship may kindly have a look at page 26. Translated copy 27 is the vernacular, showing father's name, Abdul Jabbar. Abdul has been written in short, my lord. My lord, at page 27, Jabbar, vernacular, my lord. In village Salpara. 70 similarly, my lord.
Yes.
My lord. Then, my lord, linkage Lordship, I am relying basically 3 documents. The first one, my Lordship will find at page 30, school certificate. 31 is the vernacular. She read in school up to +4 in Salpara Gosti LP school.
Was the headmaster examined?
Not examined. Apart of this, there are other 2 documents, Kabinnama, mutation also.
No, Mr. Sikdar, the question is very relevant because of the fact in page 3 of that impugned judgment,
My lord.
The last paragraph,
My lord.
that is the precise reason for which the this was rejected.
My lord, showing because of the reasons of the base house numbers are different.
No, the authors were not examined. Fourth line. In authors were
Fourth
not
line.
examined.
Fourth line, my lord, DW cannot be considered.
However, the said certificate rendered itself inadmissible in evidence, inasmuch as the authors were not examined to prove the certificates and the contents thereof.
Well, judgment of the in the writ petition, my lord.
Yes.
WPC 307.
My lord.
You gave us a copy. Page
My
1 is
yes,
the cause
yes,
title.
yes, my lord.
Those paragraphs.
Page 3 of the judgment last.
My lord. From the exhibited documents, the petition is relying on the Kaponsa certificate, exhibit 1, school transfer certificate, exhibit 2, and the Gabara certificate as links to projected father. However, the said certificate tendered itself inadmissible in evidence inasmuch as the authors were not examined to prove the certificates and the contents thereof. The petition also projected on Alam Guni as her paternal uncle, being the brother of the projected father, and the document brought on record for the purpose of establishing linkage. Alam Guni and age of birth was the Zawamudi at exhibit 5. In the said Zawamudi, the petitioner name is not reflected as co-patadar. It is seen that although the said DW1 in his testimony stated that the petitioner is his niece and the petitioner projected father Abdul Jabbar as his elder brother. However, no voter list were produced or exhibiting showing Alam Guni and Abdul Jabbar together. My lord, we have produced here, my lord, the voter list of the same house. My lord, there was some missing, my lord.
So Signal, we call for the school record.
My lord.
If you want to rely on a school certificate, let us call for the school record.
My lord, the other finding, my lord, the paternal uncle's voter list.
No, forget about the other findings. If the school record is genuine, it contains the information that the petitioner is the daughter of Abdul Jabbar of Salpara village.
No.
We'll consider it.
Well, then, my lord, one Jomandi copy also annexed here, my lord, at page 73. That may also call for, my lord.
Jamabandi, let us see. School records,
My lord.
suppose we accept that what will happen? We'll require the headmaster to go and give evidence with the original record. Instead of the headmaster giving evidence, let us satisfy ourselves on the school record. If it is satisfactory, we'll send it back. If it is not satisfactory, we'll put it across to you.
That can be done, my lord. But there are many other linkages. The Kabin Nama, the Jawamandi mutation copy. She got land from her father, my lord. At
No.
least,
As your school certificate was the first document you referred, we are reacting to that document.
Lordship.
Hmm.
My lord. Lordship.
Where is the Jamabandi?
My lord, at page
Page
73.
46.
73, my lord.
Hmm.
73, Bhandakulat 74.
What is 45? 45 is also a Jamabandi.
My lord, that relating to other land, my lord, but we are
73.
43. 43, the government Gavra certificate. We are not
No, 46.
emphasizing on that. 44, 5, my lord. 44 and 45. The land, the father got the land from grandfather.
Which entry?
My lord, page 44 and 45.
No, which particular entry?
My lord, lordship may page 47. Page 47, my lord, serial number 89. Alamgani is the paternal uncle. He is a Pattadar. Alamgani, son of Pita Ahmad. Then, my lord, father's name is at serial number 106. Abdul Jabbar, Pita Ahmad Ali. So that way there we have shown the connection.
Just now, 89.
89. Then Alamgani. Then Pita Ahmad.
Next.
Next, my lord, 106. Muhammad Abdul Jabbar, Pita Ahmad Ali. We want to show that they are two brothers.
But Mr. Sigdar, you see, the difficulty is that in many of these cases, there are few names which are very, very common. So when there's a span of, say 20 entries, and then again one Abdul Jabbar comes or Ahmed Ali comes. This Ahmed Ali is who we don't know.
My lord,
No, you understand.
that is
The
possible,
names,
my lord.
the names are so common.
My lord.
The difficulty lies there.
My lord, I have
Subsection-
annexed the 85 and 89 voter list of parents and the paternal uncle. They are voters in same house.
What is relied upon, if you come to page 26, Abdul Jabbar, son of Ahmed. Abdul Jabbar, son of Ahmed, Bhider Salpara. Now come to page 70. 70. Abdul Jabbar, son of Ahmed, Ahmed Ali.
No, Salpara.
A land is in village Salpara.
Yeah.
And this had been mutated, right hand side, second last line, Mojida Khatun. Mojida Khatun is the petitioner, I think. Yes. So, name of Mojida Khatun had been mutated in place of Abdul Jabbar because she is the daughter. This is what they are trying to establish. And here also Mojida Khatun, daughter of A. Jabbar. Now, A. Jabbar, son of Ahmed Ali, there is only one in that village Salpara, or two pairs are there. You'll have to verify.
Yes,
If there are more Abdul Jabbar, son of Ahmed Ali in the same village, there is a possibility it may be two different persons. If there is only one person, it is the petitioner has established. Or even if there are more than two persons are there, one person is there, whether this Abdul Jabbar Ahmed Ali of the Jamabandi and that Abdul Jabbar son of Ahmed of the voters list, it is the same person.
yes,
यहाँ तो डॉक्टर नाम उल्लेख नहीं किया था, डॉक्टर नाम यहाँ थे ऐसा. So I think best aspect is verify and submit a report.
Yes.
If it happens that they are two different persons, you can put it across to Mr. Sigdar, will reject it.
We can even get the school records and we'll get this verification also.
School
done.
reports definitely we are calling,
Yes.
but he is also relying on the Jamabandi, so therefore
And we will ascertain whether they are the same person. or
same
not.
person or if it is same person.
And if we get the school.
And
records
the police may also produce that school register also. Get it from the school and bring it. Why do we have to channelize only through the DO? Even the SP can go and get it.
We'll get it. District compressor.
District is possibly Nagaon.
She will pass appropriate orders, we'll get it. 2 weeks.
It is mutated in the year 2018.
Sorry,
Mutation
Mu-
order is of
it
2018.
it has to be.
No, that is, usually these orders come only after the notice of the tribunal goes.
No, no, that we understand. But when will the daughter get the name mutated in place of the father?
We can just check, when did the father die and what is her age?
No, you make your
Just,
verification.
Mrs. Verma, just, you see, let us dispassionately see this issue. Let us say father of A died in 1940,
Yes, Lord.
correct? A man does not mutate till 2018, correct? And he dies. 2019, the grandson inherits the land. Just because mutation was not done by the father, will he lose title?
It's not that.
No. And then you see, in land of Z, he will not allow mutation of name of A. A is legal heir. Because when in today's world we are fighting for 1 inch land everywhere, somebody will not allow a third party right to be created. So
We will
therefore,
get
if
it,
title will
Lordship.
not vanish with the delay.
This land, we'll have to get.
Madam
the-
Verma, one more aspect.
Yes, Lordship.
Suppose it is done after the notice. Can that be a reason to discard everything?
No, I'm not on that. I'm on. when-
No,
when
what
did
we
the
are on,
father get the land, Lordship?
Madam, we are not on what you are, we are on what we are, where we are. Suppose there is a delay of say 40 years also in mutating. Can it be a reason to reject that information? No.
Lordship, if the father.
The
is a
answer
citizen-
is,
Yes.
if you have any doubt, you will go and make an inquiry and submit a report before the court.
If
Please
the
do it.
father is a citizen, we have no doubt, Lordship.
No, no,
Everything is linked to the father.
you please do it.
Yes,
We
Lordship.
need some cooperation from the respondents also. Otherwise, how do you decide these issues?
Lordship will get it done.
Merely throwing doubt will be result of, it can either be yes or it can be no. If we cannot accept it to be yes, how we are going to reject it by claiming it, saying to be no also? The determination has to be there. No? No, if it is a concept of only.
So,
Ms. Verma, you know my background. I come from the right side of this institution, correct? I'm in civil court. Now, you see, under the Evidence Act, someone has to prove a document by primary evidence, 61.
yes, Lordship.
Now, if a document is proved by showing the original, there's one more concept. In a civil case, to prove you need evidence to be filed. But there are judgments of this court as well as Supreme Court, which says that in a writ petition, the pleading itself is a evidence and the affidavit in support is of the standard of an evidence. Now, somebody has discharged the burden by proving the original, bringing the original in court. So therefore, the burden and the onus both have been discharged. So therefore, burden remains with the petitioner, but the onus shifts to the respondents to disprove it. So that is what is in the mind. And therefore, when the document is produced, if the state has a doubt, it's the police force can, the border police can always go and look into the document and apprise the court. That becomes a task easier than call for the records. Some people will travel so long to get the record, come back, give it to us. We will examine it. Let the SP do that work. It makes the works easier.
We'll get it done.
This is what we are trying to tell you every day. Section 9 burden is on the proceeding doesn't mean it gives the respondents the inherent right to only to raise doubt and nothing beyond that. Whatever is produced, they have discharged the burden. Unless it is rebutted by the respondents, that has to be accepted. So now, once a minimum of the burden has also been discharged, onus shifts to the other side. What is pointing out. Now you'll have to rebut it. And by only raising the issue of doubt, that means it may happen, it may not happen. So by raising doubt, if you want a view of the court that it had not happened, similarly, he will say, why not take the other view that it had happened? Meaning thereby, the court cannot decide either way, either this way or that way. So we have to decide something more conclusively.
So wherever there is a
So
doubt.
this is
lordship, we get-
the
we
procedure,
will
what,
get the verification done.
what this court is trying to follow. We don't know about any other forum, what is done. But this is the correct position and appreciation of the law.
So wherever we have a doubt, we'll submit.
Always
that-
verify.
Yes, we'll submit that. we'll
And
get a
moment you
verification
verify,
done.
submit a report, we'll immediately put it across to the other side. That this is the report that is coming, that what you are saying is not.
We'll get it done.
Then again, the burden will shift to the other
Proceed.
side. Proceed now. Now you discharge your further burden now. It's like you have seen the badminton shuttle. If you sit in the middle and watch the game. Once it is hit from this side, it goes to the other side. The other side has to hit it back again to put it on the other side.
So lordship, in this one, first we'll verify whether
Verify.
Abdul Ahmed's are the same or not. And
That is the
Abdul Jabbar,
that
yes.
is the most vital and core aspect. If Jabbar son of Ahmed, this pair is a different one in respect of the Jamabandi, then they had not discharged the burden. If it is the same, then definitely it has to be accepted.
I have just a small prayer, the mutation orders or whatever Jamabandi they're relying on. If it is a complete one, because it comes only with the last order. This one is, the land was
Okay,
somewhere,
produce the complete.
this land was somewhere
Very well.
bought in 2004 as per their document. So the 2019, the daughter's name came in. Now we do not know if 66, they were there or not. Because that is where we link the
No.
person.
It's not possible. It's not possible.
Two materials are relied upon by the petitioner. One, voters list of
66.
1965, Jabbar son of Ahmed.
Yes, Lord.
So whoever is that person, Jabbar son of Ahmed of the 1965 voter list, he is a citizen. Because
Yes.
he was in existence in the state of Assam as on 1965.
65, yes, Lord.
This is one aspect. Jamabandi is one Jabbar son of Ahmed had a plot of land. Whether he purchased in 2004 or 10 or 65, it doesn't matter.
But if 66,
Just a minute. He has a plot of land. This land is now mutated in favor of one Majida Khatun.
yes,
Petitioner before the court is Majida Khatun. Majida Khatun, the name having been mutated in favor of Majida Khatun in place of Abdul Jabbar is a prima facie indication that Majida Khatun is the daughter of that Abdul Jabbar.
yes.
That Abdul Jabbar. Now, therefore, we are asking the question whether that Abdul Jabbar,
66.
no, that Abdul Jabbar of the Jamabandi, whose daughter is Majida Khatun, and this Abdul Jabbar, son of Ahmed of the 65 voters list, they are the same person.
Exactly, that is
Once it is the same person,
the due-
this Majida Khatun had discharged the burden. If they are not the same person,
then
it's
they
for
will-
Mr. Sigdar to explain.
Our job is only to see whether the Jamabandi person and the 66 person.
They are the same or not.
Same or not, that's it.
No point in raising issue on the sustainability of the Jamabandi orders, whether how can you do it this. That is for the civil court to decide on the land rights. We are not on land rights. We are only on the information that can be derived from these materials. That's all. We are not determining that. They want a full Jamabandi, give the complete Jamabandi.
My lord,
Apply for it.
My lord, the Jamabundi copy goes to show that it starts from,
Mr. Shigdar, if you
19.
refuse to give the Jamabandi, we'll understand that you are
my lord.
not providing the
will
complete
time, my
material
lord,
to the court.
uh,
Give it if they
will
want
time,
it.
my lord. But,
Instead of giving a truncated version of the Jamabandi containing only the entries which you want to rely on,
Hello.
they are asking, give us the complete Jamabandi, we want to study it. Give it.
Hello. Full time, my lord. The office is not easily respond, my lord, normally. These are.
You make an application, you tell us which office is not giving you the copy.
My lord.
Inform us. We'll ensure that you get the copy.
My lord.
Tell us which officer, which official of which office is not giving you the copy in spite of being asked for. Difficulty can be overcome. Mr. A.R. Shigdar, then counsel for the petitioner, relies on the voters list of 1965 of village Salpara, police station Rupohihat, which contains the name of A. Jabbar, son of Ahmed, at serial 179. The name of A. Jabbar also appears in the voters list of 1970 of village Salpara. It is claimed that A. Jabbar, son of Ahmed, is the father of the petitioner, Majida Khatun. To substantiate that A. Jabbar is the father of Majida Khatun, firstly, reliance is placed on a school certificate. Where is it? Where is the school certificate? Page number?
My lord, 26. I'm not wrong, my lord.
On a school certificate
Oh, sorry,
issued
sir.
by the
My lord, it will be 30, my lord. It's
30.
31.
31. Issued by the head teacher of Salpara Reserve Bosti Prathamik Vidyalaya, which contains the information that Majida Khatun is the daughter of A. Jabbar of village Salpara. But it is noticed that the author of the certificate, namely the headmaster, had not been examined. In the absence of the headmaster being examined, no evidentiary value can be attributed to the said certificate. Petitioner also relies upon the entry of a Jamabandi in respect of a plot of land at village Salpara, which earlier stood in the name of A. Jabbar, son of Ahmed Ali. As per the order of the circle of as per the order dated 24/11/2019 in mutation case number case to page 70, the land which earlier stood in the name of A. Jabbar, son of Ahmed Ali, had also been mutated, amongst others, in the name of Majida Khatun, daughter of A. Jabbar. Accordingly, it is claimed that as Majida Khatun can establish that she is the daughter of A. Jabbar through the order of the circle officer contained in the Jamabandi, therefore the burden under section 9 of the Foreigners Act 1946 had been discharged by the petitioner. If A. Jabbar, son of Ahmed Ali of the Jamabandi at page 70 and A. Jabbar, son of Ahmed in the voters list of 1965 of village Salpara are one and the same person, perhaps it can be accepted that the petitioner had discharged the burden that she is also the daughter of A. Jabbar, son of Ahmed of the voters list of 1965 and thereby discharged the burden under section 9. For the purpose, we call for a report from the Superintendent of Police Border Nogao, who shall make a verification as to whether A. Jabbar, son of Ahmed, at serial 179 of the voters list of 1965 of village Salpara, and A. Jabbar, son of Ahmed Ali, in the Jamabandi in respect of a plot of land at village Salpara, which is available at page 70 of the writ petition, are one and the same person. Secondly, the superintendent border through the district elementary education officer shall also procure a copy of the original admission register of Halpara Reserve Bosti Prathamik Vidyalaya and produce before the court for its examination on the authenticity of the entries contained therein as regards the information that Majida Khatun is the daughter of A. Jabbar of village Salpara. List down.
2 weeks, Lordship.
Because this is not a regular bench. All the matters give it in a fixed, right? Take 1 day. 8 June, Thursday. 8 June. Yes, sir.
Lot of copy of the order, lot of provided, lot of copy of the order. Petitioner copy to line,
I think,
Just a moment, Mr. Sikdar. I was just examining the, Ms. Verma. I was just examining this page 71 and 72. Correct. This appears to be complete because it starts from 1 at page 71. Goes on serially till 17 in the first page and second page is 18 to 23 and there is an end. And
Lordship is relying on the voters list.
page 71, 72, that Jamabandi.
Jama Bandi. We have 73, it is here 73, 74.
I don't, it's not matching. This is
71 and 72. Yes.
73 is a translated copy. Lordship is.
No, the
And,
next page, next page.
Next page. The printed format.
Yes,
Yes, Lord.
connection 18. You see, it starts from this Patna Notun number 14. Left side, first
Yes,
entry,
Yes, Lordship.
correct. Use the next column number 3 is serial number 1. Column number 3, no, same page. 3.
1, 2, 3, 8, 2.
And Verma, what is Lordship is indicating, this is for this purpose, the complete Jamabandi. Because it starts from
serial
1
number
and
In first page ends at 17, correct, last entry. Serial number 17,
17, yes, Lordship.
yes, correct. Next page starts from 18, ends at 23.
Unknown.
And this is complete. From the last entry, you will see 1-0-
I had
9-0-9. Correct. That the total land is 9 bigha, 9 katha.
Vicky
Oh, this is 1. This is 1 or 9. Last page 70, last page. What is that? 9. It is 9 or 1? 9. So 9.
2.
Last entry is 9. End. See this one. Last page,
Yes,
last entry in the last box of 3. Correct.
1.
It's 9 bigger. So that is 9 bigha, 0 katha, 9 lechas. So this is when it's a box enclosed and figures are given in Jamabandi, that means it is complete.
We have to translate it and go through it, Lordship, because it's from serial
No, it's okay.
One.
Well, I've just told you that it
Yes,
appears to be
Lordship.
complete.
23.
We'll do that translation. We have time.
She is so perfect in reading the records.
No, I'm not perfect. You have not seen
1, 2,
My
as
honorable brother.
others from 17, their name starts. This is what I can make out, Lordship. From 17.
So whatever way that inquiry can be made, translation can always be done.
item 2.
Ms. Verma, just one more thing. The entire entry you were referring to, my esteemed brother has just pointed out. You see, those entries, supporting entries, which relates to the earlier patta and the new patta which has been issued, can only be found in a chitha.
Chithan.
Yes.
Exactly.
So your officer, when they go, they must know how to read the land records, because you have a earlier Jamabandi, then there is a Zarif and fresh cadastral mapping, and then second Jamabandi. The connecting entries are always in the chitha.
Our concern is only that if he's there in 66, and this person is
So
the
since
same.
you had that query, I'm just explaining.
Yes, Lordship.
The link would always be in the chitha, not in the Jamabandi.
Yes, Chitha.
So you can ask your officers to. Yes.
Yes, Mr. L.R. Mujumdar.
Pilot in this case,
What is
there
this
is a
IA?
lots of delay, condemnation of delay, lordship, there is a delay of 375 days in preparing.
Had it been condoned?
No, lordship. Today is the first.
Will you have to delay to condone?
We have stated it, there are two lordship,
Heard, Mr. How many days delay? Yes, Mr. Sharma. Are you objecting to the condoning the delay?
I have to see. Just a minute, Lordship.
Are you objecting to the condone the delay?
Yes. Lordship may condone.
Lordship may condone it.
Heard Mr. L.R. Mujumdar and counsel for the petitioner. This interlocutory application is instituted for condoning the delay of 592 days in instituting review petition civil 97/2020 against the order dated 26/8/2019 in WPC 4405/2019. The reasons for the delay had been explained in paragraph 2 of the application. The learned counsel for the respondents also do not object to the delay being condoned. In view of the above, delay of 592 days is condoned. I allowed raised it to list the review petition for its consideration. Same date.
Lordship, the days, I think it is 300 something, not 500. Lordship.
Did I read
Just said-
it wrongly?
Lordship, it just said 590, and my friend is saying.
In our copy, it is
397.
92.
Oh,
or lordship,
then-
it was calculated by the filing section and then it was, they extended. We have
My
I-
friend submitted 3
Eh,
something.
filing section.
আপনি তো 397 করছে। 592, almost 2 years. আপনি ভুল করেছে দেখলাম। I heard what him saying 395. We simply didn't have the file.
Are you objecting to 592? If you're objecting, next question will be why. The reasons.
Like.
Item 3,
Yes, Mr.
I'm happy. Last order, my lord. And directed the petitioner to file affidavit.
Affidavit to
explain
file
that
as required by the order of condoning delay.
Yes.
File it.
You know, already, my lord, directed to file affidavit, my lord. Already filed affidavit.
File application as required by the earlier order. What is the earlier order?
And the times.
File application for condoning the delay.
To my.
So unless you file application for condoning the delay, we cannot proceed any further. Did you file?
Affidavit already filed, my lord.
Not affidavit, application.
My lord, first order, I think, my lord, initial order, my lord.
Order of 11/8/2022. দেখা দিও ভাই।
28 to.
Mr. Motin, please make the habit of reading the orders also. All of you.
delay condone কৰিলে সদায় আয়ে পাৰি কৰিব লাগিব।
We are not required to send our file for every matter.
Because
Read the third paragraph from the bottom, order of 11/8/2022. Affidavit to know.
Yes, yes.
আয়ে
I think the requirement is application, not affidavit.
Yes, my lord. I think, my lord, that's why I have filed it.
If you have read the order wrongly, you cannot be helped.
Yes.
Mr. A. Motin, Land Council petitioner, says that instead of an application for condoning the delay, inadvertently an affidavit had been filed. The Land Council seeks for some further time to file the required application for condoning the delay.
Obvious.
File it before the next day. This bench is available on that given day,
8 June.
8 June, file it before that. For that reason.
Yes.
Item 4,
Please, Father. Yes, Mr. Ganguly. Converting the delay application.
Petition is also directed against
Mr. There's some
dated
delay, I think. Delay,
Not file lodge. I will file.
because now I think there is a judicial order that in a review, if there is delay, you are required to file application to condone the delay. So we'll have to follow it. Mr. A. Ganguly, Land Council for the petitioner, prays for some time to file an application for condoning the delay as may be advised. Response also, that 8 June, file it before 8 June.
Excuse me, I'm appearing on behalf of Mr. B.C. Das. So matter will be fixed on 23rd.
Adjourn on the prayer of turn number the vote. We just know.
Obligement.
Yeah, thank you.
item 1 for motion.
Make a resolution. Page 23, my lord. Page 23, border list of 965 of village Tengulia of Border district. And next page 24,
Who is the father?
no, petitioner himself, my lord.
Petitioner himself is in 1965.
Yes, ma'am. Abdul Wahab, my lord.
Abdullah Mullah. Where is the order of reference?
Abdul Wahab, page 1.
Where is the reference?
104
page
serial
59.
lordship.
104.
Oh, no, at page 24, the petitioner's name is at serial 104 Abdul Wahab.
Abdul Mullah or Abdul
Abdul
Wahab?
Wahab, Abdul Wahab.
Abdul Wahab.
Abdul Wahab.
He is the petitioner.
Yeah. Yes, reference page 59, my lord.
Reference is page 59.
Notice, my lord. Abdul Wahab, Pita, Faizuddin Mullah, Gau, Singulia. Same person, my lord. So study item number 1, your lordship already held, my lord. Yes.
Yes, Madam Burma. Why the tribunal rejected this one?
They have tribunal no finding about the, my lord, 66 voter list and 70 voter list.
No, they did not even consider it.
Yes, my lord. Kindly see the order.
Where is the order?
Page 90, my lord.
90.
Yes, only mentioned, but there is no discussion about 66 voter list and 70 voter list, my lord. 70 also, his name also there, my lord.
90. Where did he take note of this voters list?
Page 92,
Computerized certified voters list. 65.
just mention, my lord, that there is no finding on that, my lord.
He's still alive.
Yes, my lord, 90 years. Now, today, my friend called me.
So you want a birthday
For
gift?
this case, my lord, is,
Today is the birthday. So you want a birthday gift.
my lord.
What do you say?
I'm just looking at the opinion, why the tribunal rejected lordship.
It's never rejected. He did not even consider.
No, did not consider and.
Did not even look at it also.
There's just a mention, she went more by the written statement. This is what I can see, lordship.
No, written statement, they say too many things because firstly, one lawyer will be there. The lawyer has a definite pattern of taking up matters.
This like-
Bring whatever you have. The person will bring one sack full of materials that these are my material. Lawyer will take out one thing, write everything. The application of mine does not take place at that stage.
Lordship.
And this is done because tribunals take a view that if you don't mention in the WS, we are not going to consider it. So at the time of WS, they don't take any chance. They mention everything. Now, if one document proves it, it is immaterial whether the other documents disproves it.
Tribunal has erred in not discussing the 66, 65 and 70 voters list. So lordship may remand it back, asking the tribunal to look into these two documents specifically, because the petitioner himself.
No, 190 or 90 years. Again, trouble, he will have to go there.
Lordship.
Man appearing in the 65 voters list, perhaps he is right. As on today, he may be 90-year-old.
He may be lordship.
So just imagine a 90-year-old man who must be waiting, counting his days when it will come to an end, relaxing at home. Now have to take all the burden of going to the tribunal, proving this, proving that, and when he had already discharged it. 70. 70 plus. Is there in 70 also? So moment this material is available, only question we are going to ask is this procedure and that man same or not?
Same. Let us
You
get a
give the answer.
verification done.
So you give that answer.
We will get a verification done, lordship.
So not today.
This is.
Then we keep it pending with us.
Yes. Forfeiture, we can get it done in 8-9 days. Whether the Abdul Wahab of 65 list and
No. We will declare that Abdul Wahab, son of Faizuddin of the voters list of 65 is a citizen.
yes,
Don't disturb that man. If you feel that your procedure is somebody different, go and serve it to him.
lordship, in the 70 voters list, the father's name changes
No.
to Mullah.
Maybe,
Abdul Wahab,
no, we are on Abdul Wahab.
yes.
Forget about 70. Do you mean to say that if 70 says Abdul Mullah instead of Abdul Wahab, so discard everybody? It cannot be.
We're not discussing, and he has referred to only 65 and 70, and then he comes to 85.
No, what we are going to do is, we're going to declare Abdul Wahab, son of Faizuddin of the 65 voters list of village Sengolia to be an Indian citizen. If the respondents have any issue that the petitioner is somebody different, go and serve it to him. Don't serve to this man.
Should not serve him, lordship, he himself. Lordship.
Okay, now we will say, if the respondents have any doubt that the person to whom it is served is not this man, don't serve it on this man, serve it to that man. Kind of. We'll give you that liberty to proceed against that man once again. But that man cannot be against this man.
But lordship, the reference and the voters list, my friend has said they are the same person. page 59, he has just referred to the page 58 reference by the police. He says it's the same person. So if
No.
he agrees that he's the same person.
We are not going anything beyond that. Whether he agrees or he does not agree, we are going to declare Abdul Wahab of the 65 to be an Indian citizen. We'll also provide, don't disturb this man, this 90-year-old man. If the respondents have any issue that the proceedee may not this man, go and serve to any other proceedee, but not to this man.
That's what happened this way. We cannot serve to any other proceeding. Person who's not able to establish, give documents.
Okay, we are passing our order.
Yes,
we are
lordship
going
may pass orders, but like lordships, go and serve it to somebody else.
See,
It's
we-
not that we randomly serve notices to people.
We just declared this man to be one.
Lordship may do that.
Heard? Maybe not. Or you want to verify the next week, get it verified, tell us.
That was my first submission. We'll get it verified in 8 weeks' time. After a week, lordship
This
may-
one so and so, in order to enable the respondents in the
SP
Home
border
Department to verify
auditor.
as to whether Abdul Wahab, son of Faizuddin of the 1965 voters list of village Chengulia, and where is that one?
Yes,
Page
50.
50.
59.
And Abdul Wahab, son of Abdul Wahab of village Chengulia, to whom the notice had been issued by the tribunal, are one and the same person.
29th May.
Obliged to me.
Item 2.
Abdul Wahab and Oheb lordship, he has two names. That is the reason there is some,
You find out, tell us.
a
No,
copy of this order.
some people should not be disturbed also. 90-year-old man,
Copy of this order may be. sent.
he at least he had earned something in his life. That for the remaining days in his life, he should live peacefully.
Lordship, we have nothing to say on that. Lordship has already.
So we have passed our order. Please. Yes, Nick.
My lord, in this case, last occasion, your lordship directed,
Pursuant inquiry conducted lodged with the duty operators, government notice the FIR has been lodged before the officers shall submit a report of the status of the investigation.
that is, my lord, my lord, investigation is going on, my lord, that report I have
Status.
received, my lord. Status is, my lord, pending, my lord.
Status
Investigation
can
is-
never be pending.
my
status
lord,
is-
investigation is going
Madam,
on.
status can be that
Madam.
we have registered the case, but we have not done anything till today.
Already registered, my lord.
Madam Deca, Das, sorry. Status can be only one thing.
Sorry, my lord, I have
That
said
nothing had been done in the investigation.
that I have said, but my lord, already registered, my lord, and the investigation is going on, my lord. That is the report.
We are not
I have-
happy with it.
My lord, I
Yeah,
have
it's
received
not-
that.
We are not happy.
My lord,
Ask him to remain personally present, also, if he is behaving in this way.
my lord, that is the letter, my lord.
We don't accept it. You don't have to give us.
My lord,
Status means
my lord,
till today, what we have done, please tell us.
investigation
Aha,
is on.
investigation is going on is not a status. Investigation is going on is only a claim being made.
My lord,
Status is
my lord,
that we went to so and so, found this material, we did this, we found this
My-
material.
61 statement has been recorded, my lord.
Please show it.
My lord, I have given it.
Then don't use these expressions, investigation going on. Ask this OC not to use it in a court of law.
That is.
When the court
written,
asks for status report, it is status report.
my lord.
And it is not an information whether it is going on or not.
My lord, Later, my lord, later written to me is, my lord, that during investigation of the case, collected a copy of inquiry report from the complainant, visited the place of occurrence of the case and examined the headmaster of the school and other office staff and recorded their statement under section 161 CRPC checking.
The officer in charge of Julia Police Station to submit a detailed, up-to-date status of the investigation rather than providing the information to the court as to what he had done.
My lord,
List tomorrow.
tomorrow, my
Okay, Monday.
Monday, my lord, deeply obliged.
Ask him to, when the
My
court wants it, wants it.
My lord, I am also
Mm.
not happy with this letter.
These
but-
evasive things, ask him not to do it.
Monday কেলে নহব? আজিলৈকে কি কৰিছে? My lord, Monday.
Item 3.
You are ready with the hearing? Are you ready with the hearing?
Yes, ma'am.
Okay, start.
In my case,
Nazia Hassan, who is the father of Nazia Hassan?
Ramzan Ali Sarkar.
Page number?
Page number 1. My father was a government employee, state government employee.
Mr. Das, we have asked you, who is the father of the petitioner? In which document, in which page his name appears?
In the first place.
You come prepared with the answer. We'll hear it. Let's next week. Let's wait for next time.
18.
We want only two information. Last time also we told you. Who is the father of this man? In which document, in which page his name appears? We want to examine that. Second, we want which material, which document will show that this person is the son or daughter of that person. We don't want anything beyond that to start with. Later on, if necessary, we'll hear you more also. But first we start with this two minimum information. Next item, Spock. Baniwala Das, who is the father?
Father is my Padhar Das, my lord.
Page number?
97, page 16, madam.
Page 16.
My
Adhar
lord.
Das.
My lord, Adhar Das. my lord.
Adhar Das is the father, son
Father.
of Gotu Das.
And
And which document will show Adhar Das is the father?
my lord, there is no direct linkage, my lord, but petitioner's brother, my lord, who had also deposed.
Brother.
Brother. In the brother.
Any material which will show name of the brother and Adhar Das together?
My lord,
If that man is the brother,
my lord,
he also must be the son of Adhar Das.
my lord.
Which document will show their name together?
My lord, may pay some time, my lord.
Mr. S. Hall, answer petitioner seeks for an adjournment to provide the information as to which document or material shows the name of Adhar Das of serial 30 of the voters list of 1997 of village Gerality and that of, what is the name of the brother?
Brother, my lord,
Item 5.
Prepare, come, tell us next. Yes, sir.
May I please, your lord?
Same question, Suleiman Ali, who is the father?
Item 6,
Page-
page 15, madam.
Page 16. This is some land document, purchaser Sofar Ali's son of
Page
Muhammad
15, my
Abdul
lord, 15.
Aziz. In Akipara. Village Tikna Para. And this is the sale deed of which year? Even 80, 17.
My lord, I am referring page 15, my lord, 15.
15.
15. Sofar Ali is my father, but here title is recorded as Uddin, my lord.
Who is the father? Sofaruddin.
Sofar Ali, actually he is Sofar Ali, but here. title
No, we
is-
cannot go by any actual. We can go by Sofaruddin of 66.
My father deposed before the honorable court regarding the title also he has
First, you have to show he is the father.
Sofaruddin Manor.
Now, because fathers and uncles and brothers are available everywhere. You can bring any person from the street and tell that he is my father, this is the deposition. So before that, you also have to show that that man who deposes is the father. Or at least that he is a person whose name appears in any document which will show that he himself is a citizen.
This is the very document, my lord. Page 1566 voter list, Sofaruddin.
Sofaruddin.
Father's name is Abdullah Ali.
85, his name appears as Sofar Ali. Earlier, Sofaruddin is somebody else. And from 85, the name starts. Lordship.
And why did you annex page 17 some sale deed?
Because of shifting, my lord, earlier village is Dumuria part 3. And the next voter list I have annexed 70, it is also Dumuria part 3. But 1985 voter list, my father's name is appearing along with me. That is from village Piknapara. And regarding the shifting, my father purchased the plot of land at Piknapara. Thereafter shifted.
Mr. Alim, there is a difference between a story being presented and facts being presented. Facts are always substantiated. Stories are always told. Keep the difference in mind and then make your submission.
Otherwise, my lord, as so far Ali, I have no document prior to 70.
Then you have to prove it.
85 is the first document.
We can grant you time to bring any material, but you'll have to bring something.
But if your lordship considers the other family member name, my mother's name is appearing same in the 66 voter list as well as 85
Zobeda.
voter list. Yes, madam.
So now, where does name of Joveda appear again?
In the voter list of 66 also your lordship will find
66, we have noticed it, and after that,
70, my lord,
page number.
page 21, my lord.
No, but in 85 again, that's.
But he is also Sofaruddin.
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 And then he becomes Sofar
The
Ali.
difficulty is Ali and Sofaruddin.
My lord, kindly consider one thing, that father's name is same and my mother's name is also appearing in the same voter list, same number.
Who is Khadija Khatun?
Stepmother, mine. Second wife.
And who is Suleiman Ali?
Suleiman Ali, I am myself, my lord.
Petitioner lordship.
Suleiman Ali. So why the name of stepmother was not there in 66 and 70? Not married at
Not married, ma'am. Subsequently married.
77.
77, I do not have in possession.
Get it?
My lord.
Mhm. See, there is one variation we can accept it. Name may go little here and there. Or the age may go little here and there. But when there are more than one variation, the village is different, name is different, age is different, then how can you ignore three variations and then say, accept your statement, yes, it is. So that means we are accepting more of a statement being made rather than a fact being established. Law requires to establish a fact, not
Yes,
only to make a statement.
But while my father deposed before the tribunal, he was
Again,
not
it's
even
a-
cross-examined
Again,
regarding that.
Mr. Ali, it is a statement you are making. Statement you can make many more, but that not make it convert it to a fact being established.
My lord, sometime may be allowed, I have to gather
Mr.
the
Salim,
information.
6 point adjournment to provide any material that Sofaruddin, son of Abdul Aziz of the 1966 voters list of village Dumuria part 3 and Sofar Ali, son of Abdul Aziz of the 1985 voters list of village Piknapara are one and the same person.
89, again, the village changes. Again, it changes in 97. And there's no explanation to that, why the village is changing, Lordship.
Every 5 years you change the village.
No, my lord, that is Dumuria part 3. I have 2 houses at earlier place Dumuria. I have purchased a new plot of land at Piknapara.
But that doesn't mean the voter list keeps changing, Lordship.
আপনার কোন ভোটার লিস্টত আছে?
Every village, that means his name is figuring in all the
Yeah.
villages.
Try to have some information from leadership where his name appears. So it is there.
But offense is only if my name is
Mr.
appearing in the voter list.
Alim, it is little difficult to believe when you say that with purchase of every property in a different village, your voter list also keeps changing from village to village. Ask Madam Burma where her name appears and which other places she may having houses. Her name is not shifting from every place she is having a house.
Normally enumerator
So-
enters the name.
So,
Why-
Mr. Alim, this is an abnormal situation. Moment you express the word normally, means yours is an abnormal situation. You explain it
My
with materials.
Oblige, ma'am.
Item 6 for admission.
Muhammad Ali, who is the father?
My lord, lordship will find and Tribunal Kiras Patta is 35.
35.
Yes, my lord. Syed Ali, son of Azimuddin in village Puraga.
35 is some to Sahid Ali
Syed Ali.
by the deputy commissioner.
Yes. Yes, my lord. Annual Kiras Patta of village Puraga. Voter list are also there, my lord.
This is Sahid Ali, son of Azimuddin.
Azimuddin.
So he is the father.
Father. Syed Ali is the father.
Which document will show?
My lord,
Sahid Ali of this
at page 41, my lord.
page
Page
41.
41. Father, little variation of father's name, Syed Ali Devani, Azimuddin, my lord. The village elders are given title Devani. Sakina is mother. Abdullah is elder brother, Muhammad Ali the proceeding. In same village,
They're going to which village? Village
41.
39 is also there, huh? 70
Yes.
voters.
70 voter list also there, 65 voter list was there. And the brother Abdullah, my lord, was examined.
Is it a KD? Yes.
It seems the state has not,
The
state has not cross-examined lordship.
No,
cross examine who?
Cross, my lord.
Going through it, lordship.
My lord,
Uh,
Prosody and the Gavra and the elder brother were examined. All are cross-examined.
Or we can do a verification, lordship.
Make a
Yes,
verification.
we'll do a verification.
Third, Mr. A.R. Sida, Land Council for the petitioner also.
SP water.
The petitioner Muhammad Ali had been referred to the Foreigners Tribunal number.
Tribunal number, application, my number.
What is that
Barbata,
order of the FT page number?
page 65, my lord.
65. Has been referred to the
65.
Lordship, Prosingi's father had
Right.
4 LICs. At last it was Sayadam.
You do one thing, you line up all the 5 LISs
But
And
whether the
and if
father-
the line you find only 1%, that means same.
but whether
If you find 2%,
It's
is
like-
it is wrong.
Now, whether the father is
Yes.
alive or not, father is alive,
Other, because at 989.
because
No.
5 aliases of the father.
Then what can be done?
My elder brother was examined.
How do we know?
Elder brother who is brutal, my parents and the
Make
proceeding.
some field
Make the
verification.
examine.
That's the only way out. Otherwise, he will go on saying something.
Because all voters list.
Well,
have
see,
different names,
difficulty is, he is going to take all kind of stand, and you cannot stop him. If I decide in his favor, it will be wrong. Because something is lacking. If I decide in your favor, will again be wrong, because again further something will be lacking. Nor we can dismiss a petition saying that it is indeterminable disputed question of fact, because this is a writ proceeding of a different nature, not a regular writ proceeding. Only answer is make a verification and tell us.
Very interesting fact, Lordship, the tribunal has said that the proceedings name is the same, but the father's is Sayadam.
Hmm?
Lordship may kindly come to page 70, Lordship. Page 70, the second last paragraph, proceeding deposed that the notice which was issued by the tribunal was in the name of Muhammad Ali, which is his name. But in the said notice, his father's name written as Sayadam. He deposed in his cross-examination that his father's name is not Sayadam. Now the question arises, if Sayadam is not his father, why proceedee
This side.
at the first place accepted the notice? There, just to prove his citizenship, he has mismatched the documents, Lordship. And in the written statement evidence on affidavit proceeding never mentioned anything in this regard, only that his father's name mistakenly recorded as Sayadam. Proceeding stated that Sahed Ali, Muhammad Sahed Ali Sheikh, Sahed Ali Diwan, Syed and Syed Ali is one and the same person. This, with so many documents, Lordship, and the person not
Well,
being there, it is not
Sayadam,
easy.
Sayadam is not the father, my lord. That is their petitioner's case, my lord. That is,
But-
notice is wrongly issued, but he,
Now he's
as he
taking
saw-
his plea, Lordship. Initially, when he started his submission, that was not his plea.
my lord, that notice is recorded in your documents.
So
Your
why-
documents,
I'm
your
not-
father's name is wrongly recorded,
I have not written it and you have gone and
My
proved
lord,
your citizenship.
my lord. Here and there some variation, the Syed Ali,
Some
Uh,
variation. This
uh,
was-
Syed Ali is the annual Kiras Patta, then voter list, my lord, Syed Ali is 65. Then my lord 70 also Syed Ali. Look, where he got my lord Syedam,
You cannot
Well,
question
it's-
it now after contesting the case for 3-4 years. Now you're
Oh, oh.
bringing up this point. You should have taken it up then.
Ye-
When was your opinion passed? Look into that.
therefore before your lordship, my lord. Because of this, all this. Because of the minor discrepancies of title of the Devani Syed Ali, Syed Ali Devani, this type of variation. Not always. Father's name is Syed Ali in 65, in
Madam,
70 also,
Madam
land
Verma,
record also.
Madam Verma,
Yes, Lordship.
whether the principle of this acquiescence is applicable here.
Lordship, I can't hear Lordship. It is my that one.
She was asking whether the principle of waiver and acquiescence is applicable, because you said after 3 years you can't take that stand. That means the principle of waiver and acquiescence is applicable.
No, I'm.
So if it is so, under what circumstance waiver and acquiescence is applicable and under what circumstance it is not applicable?
I'll have
Please
to
tell
look
us.
into that, Lordship. because
If you say, then we'll examine whether this circumstance it is applicable or not.
we were I'll definitely look into it because why I'm made this submission is his plea was something else. When
Understand.
I took the brought it
Verma,
up, he shifted.
Anna Verma, we have the habit of understanding everything. That's a difficulty. It's not that we have not understood. he had taken the stand that he is not son of Sayadam now after 3-4 years.
Yes.
This is the issue you are raising. Just a minute. So second thing you say that after 3-4 years, now we cannot take it. We accept it.
He can
The-
take it, but he
meaning
should
thereby-
take it at the right
Meaning
place.
thereby that the law of waiver and acquiescence is applicable in this case. So we are asking you, what are the principles of waiver and acquiescence? And then examine whether in this
Yes.
circumstance it will be applicable or it will not be applicable.
Lordship, I will look into it. Lordship may fix up another day. Because it helps.
John, on the prayer, MSA Burma Land Council for the Council for the responding Home Department. It has been submitted by MSA Verma that the petitioner had not raised the issue that he is not the son of Sayadam when he first appeared before the tribunal, and it is being taken only at a later stage after 3 to 4 years. In other words, if that is the stand of the respondents, we have to understand that the law of waiver and acquiescence is being made applicable against the petitioner. The respondents may make submissions on the foresaid issue. In the meantime, the respondents may also make a verification as to whether who was that page number,
My lord,
as to whether
35,
uh,
35.
the petitioner is the son of Sahed Ali Sheikh, son of, what is that, son?
Sahed Ali,
No,
Page
Sahed Ali is the
71.
petitioner. No,
Lordship,
I
page
mean, page
71.
36.
Muhammad Ali. Petitioner is Muhammad Ali, son of Sahed Ali.
That's what I'm saying. I'm at page 36.
My lord.
Kiras Patta. Sahed Ali, son of
Sahed Ali, son of Azimuddin,
Sayadam.
Azimuddin. my lord.
Azimuddin. কি লিখিলো? Whether Sahed Ali Sheikh, son of Azimuddin, whose name appears in the annual Kiraz Patta of 25/3/1965 at page 36, is the father of the writ petitioner proceedee Muhammad Ali. List one.
1st June. Item 7.
Some more time, Lordship.
8 June.
After 10th June, please.
Item 7.
You also produce any further material, whatever you have, to erase the objections, right? If you have something, please bring it. The petitioner may also bring in any further material if available. Yes, Mr. Islam.
Lordship, I pay for a
Would-
copy of this order because we have to get the verification done.
They don't listen to you.
Lordship.
They don't listen to you.
No, Lordship, Lordship's order has more value for.
Somewhat Purima Bibi. Yes, who is the father?
May I please, your lordship. My lord, petitioner is a citizen of India by birth, my lord.
If the petitioner is a citizen, why is he before
My
this
lord, can you see
proceeding?
birth certificate page 28, my lord,
Page 28.
issued by the secretary, Binnakata Gram Panchayat.
Where is the authority of the Gaon Panchayat to issue a birth certificate?
My lord, section,
Panchayat Act.
Panchayat Act,
Let us see.
section 19. Section 19, 19, Roman 19, and rule clause 9, my lord. Issue of birth and death certificate within the jurisdiction of the panchayat, my lord.
Section
Section 19,
19.
section 19, Roman 19, my lord.
Section 19, Roman
19, public health and family welfare.
19. Roman 19.
19.
Roman. How do you read all these Roman things?
It's a mallet, it's a clause maybe. Then mallet the subclause 9.
Why do we all believe so much in Roman when the Indian system is much more easier? The decimal system, the Indian system, is ultimately adopted by the whole world. Why do we again go back to Roman? 19 PSL.
Lordship has the same book, then the page number can be found.
Page number 26.
Now, there is a particular act called Registration of Death and Birth Act.
Yes, Lord.
There is a thing.
My
So now, which of the two provisions will prevail?
lord, if my lord, the Registration Act prevails, then my lord, fact cannot be denied, my lord.
Mhm.
The contents of the my lord certificate that cannot be.
No,
denied,
no.
my lord.
Who will maintain this
incompetent authority, madam.
birth and death?
My lord, may be issued by an incompetent authority, but the contents in the certificate, my lord, that cannot be denied. And my lord, the certificate was authenticated by registrar, my lord.
Mhm.
Which
Yes,
page are you
It's
referring
a
to?
Purana certificate, 86.
Page 29 is the my lord photocopy,
It's an old certificate, 13,886.
my lord.
Before maybe কোনখন prevail কৰিব, পঞ্চায়ত আৰু এইখন? আগতেতো এটা সময়ত আপোনাৰ ডেট অফ বাৰ্থখন মেট্ৰিক চাৰ্টিফিকেটৰ পাইছে এডমিট কাৰ্ড মেইনটেইন নকৰিছিল আকৌ 86তো হয়তো মেইনটেইন কৰা নাই। 86
No,
It was 1970 and about there to while then.
no, it is not, it is not.
We have any other material?
Yes, your lordship, but my lord, Citizenship Act, my lord, section 3,
We ask you again another question.
my lord.
That provision you read is an act of 1994.
My lord,
This is a certificate of 1986.
my lord.
Prior to the act, did the earlier act also provide for something similar? There are, before the 1994 Panchayat Act, I think it was 86th Act or something was prevailing. Prior to it was the 1972 Panchayat Act.
Right now, my lord, this 72
Complication.
is not available.
So why do you have any other document?
Yes, your lordship.
Who is the father of the, where does
Father,
his
my
name
lord,
appear?
Father, my lord, page 32,
32.
father, school certificate of our father, my lord. PR Ali, MD PR Ali, son of
Pierre
Jobbar,
is the father,
father, my lord.
son of Jobbar
Jobbar is the grandfather, my lord.
of village
Village-
Sakaripara,
Sakaripara,
South Salma.
yes, South Chalmara. Then Dhubri district, my lord.
This is Pierre Ali.
PR Ali.
And which document will show that the petitioner is the daughter of Pierre Ali?
My lord, daughter of PR Ali is the my lord certificate, birth certificate.
Other than that, birth certificate will have to go into too many other laws. Any other document?
Other document not because she was married before 18.
Kavin Nama?
Cabin number is not registered marriage, my lord, the unregistered marriage.
Is the birth? 26. 20.
Then my lord, his grandfather's name in the voter list of 1966.
Sorry, delegate who is the report to me. You don't have any other document?
My lord, the next my lord exhibit be page 30, my lord. Because she was married with Shohar, Shohar is husband, and at that time
No, any document to show
my lord.
that the petitioner is the daughter of whatever that PR Ali,
No, my lord. No
any,
other-
nothing.
No other document.
Lordship, regarding the birth certificate, two witnesses were called for and they both denied issuing the birth certificate. Lordship will come to
They
page,
denied this
page
birth
fif-
certificate.
page 54 and HS 16. Lordship may kindly come to reasons and the opinion
54.
54. Right below reasons and.
But where
decision.
is that evidence? Let us see.
My lord, page 50 is the evidence.
Page 1550.
Page 50, my lord. 50. They examine one Sahanara Khatun, VCDC member, my lord,
That's a
VCDC.
member foreign, no, who is this deposition? Madhusudam Kolita. Dr. Kosugao. My office had not issued this certificate. Very well. Who is the other one?
Other one is page 50.
I do not
Another-
know about the birth certificate anymore. I also don't know about. the
Dr.
certificate.
Madhusudan Kalita is at 50, Lordship.
They have denied.
Yes, Lordship.
My lord, what happened, my lord? VCDC found in, my lord,
But
No, even if VCDC formed later, they are.
well, VCDC found in 2003 and certificate issued by
Certificate issued prior to that.
secretary.
Check.
Janasaster Vibhag means the health department.
Doctor has herself certified,
Public,
come and deposed.
public health engineering here, sir. Janasaster, public health. There is no public health department. There is a health department and there is one public health engineering department. And those hand pumps and all those you put up. Who had issued this? पंजीयन नंबर पंजीयन तारीख सब আছে it's who will appear health department or PHED
This is.
health for cover part of it. Health department yes. We'll ask the health department to produce the original register.
And they have already denied that this is not issued.
No, they may not have issued, but it's a register. Let us call for the register. Because there is a definite number, Ponzion number 83, Ponzion or Tariq 33, 1980. We'll call for the original register of bearing that serial number and that date.
Yes, Lordship.
If it contains the information, we accept. It doesn't contain.
But one thing is surprising, public health department never issues.
This is
What
what we are
certificate?
also asking.
It-
There is nothing called public health department.
department.
There is either a health department
Yes.
or there is a public health engineering department.
Yes. PhD.
Engineering has nothing to do with health. They'll put up those hand pumps and all different things in the villages.
But it says Assam Sarkar.
And the health department will maintain those dispensaries, etc.
My lord, page 50,
Even page 29 document.
Where is the origin of this document? Let us see. original copy?
Certificate.
my lord, exhibit, my lord,
Mhm. Exhibit.
exhibit, my lord, exhibit A.
It has been the records, Lordship.
What else are you having? List of exhibits. 33%. Please, Compared with the original, you must be having the original. Let us see. Record says this one, compared with the original. So something must have been produced. Let us see.
Medium record, my lord, exhibit.
It must be, they compared and gave it back to you.
Normally, when a document is compared, it is returned back. এটি দেখাও তো। তেওঁকো দেখাওক আর গগৈকেও দেখাওক। Mr. Gogoi, we want your view that document আগে ইসলামক দেখাওক। Mr. Islam, you just see that there is an endorsement compared with the original. Below one stamp. If it is compared with the original, after comparison, it must have been returned back. Can we take a look at it? Gogoi দিয়ক। জনস্বাস্থ্য বিভাগ। জনস্বাস্থ্য is the health department. No, there is no public health department. There is public health engineering department or there is health department. Do you have any public? Maybe it was having a different name in 86 because nomenclatures keep on changing from time to time. You take note of that Ponzion number and Ponzion Tarif. Can you produce the original register?
Yes, that I will, I can tell.
Hmm.
I can tell. Well,
Photocopy এটা দি দিব তেওঁক এখনত। Photocopy a record বা কৰক, it will be better copy than this one. We'll provide you with a photocopy. We want the original register.
well,
And there is no other document other than this one.
not-
That's very nice, my boy. And please take note on the left-hand side of that document issued by the secretary of some Gaon Panchayat.
Gaon Panchayat. Whether Gaon Panchayat.
And Mr. Islam refers to some section 19 Roman 9
Yes.
Roman 19,
119.
which says that the Gaon Panchayat also has a function of issuing death and birth certificate. Maybe the records are kept in the office of the Gaon Panchayat also, you don't know.
that I will.
Mr. Gogoi, we are providing with a copy, 2 copies.
Not so.
One our order and as well as this one. Give it to the learned council of the PNRD also.
Not so.
If it is records are with the Gaon Panchayat, so
Yeah,
that
yeah.
he can bring it,
Well,
the original register.
Okay.
And if it is with the health department, you bring it.
well,
The petitioner relies upon a certificate at page 29 of the writ petition issued by the secretary, what Gaon Panchayat?
Secretary, my lord,
Vidya-
Binakata, Gaon Panchayat.
Binakata Gaon Panchayat, dated 13/8/1986. Birth certificate will be going. Birth certificate. জন্ম প্রমাণপত্র, which contains the information that Kariman Nessa is the daughter of P.R. Ali Sheikh of village Motiapara. Number 1 Motiapara. The certificate contains the information that the registration number is 83 and that the date of registration is 33/1980. It is issued in a format of the government of Assam, of the public health department. We accordingly request the learned council for the health department to produce the register in original corresponding to registration number 83 as well as the registration date 33/1980 in respect of the petitioner. But as the certificate has been issued by the Secretary Binakata Gaon Panchayat,
Seven.
we also, if the records, original records are available in the office of the Gaon Panchayat, we require the learned counsel for the PNRD to take up with the concerned Gaon Panchayat and produce the records as indicated above.
Page
A
two.
copy of this order being made available to both Mr. B. Gogoi, learned counsel for the Health Department, as well as the learned standing counsel for the PNRD. List on.
After 10 days.
List on.
First June.
Interim may be continuous, man.
Hmm?
Interim may be continuous.
Interim is there.
my lord.
Interim to continue.
My lord.
नहीं तो और बेलेग document नहीं भी
Item 8,
You don't have any other material other than this one.
No, my lord.
So we'll have to look into.
No
It
option.
may be a right genuine information document, it may not be also. Let us examine.
Please, your lordship, my lord, in this case, my lord,
Who is the father of Arfan Ali?
my lord. Father of Arfan Ali is Allah box.
Page number.
My lord, page number 34. My lord, sorry, my lord, page number 45, my lord, exhibit 7. Is a
45.
certificate, my lord, issued by the Gambura. my lord.
Don't you have any voters list of the father?
My lord, father.
Why don't you refer to that?
My lord, Arfan Ali, son of Allah box.
No, no. Who is the father? Allah box.
Allah box,
Where does the name of Allah box appear?
my lord. Allah box appeared, my lord, and page number 34,
34.
my lord. Is a my lord, voter list of 1966. And mother Ujala Khatun,
Allah box 1966.
my lord.
Village Chotola Nongke.
Sotola Nonke,
Chotola Nongke. Allah box is the father.
father,
Ujala Khatun is the mother.
mother.
Which document will show
My lord, only Gambura,
Arfan Ali, only Gambura?
Gambura certificate.
Anything more?
No, my lord. And the Gambura examined, my lord. That is, my lord, the,
From where did Gambura procure this information? What is the source of his information?
but they are residing in same area, my lord.
Has he stated?
My lord, page,
Where-
my lord, 47,
Page 47.
47. I personally know the opposite
Sorman
party.
Ali Talukdar. What is the age of this man?
My lord, his date of birth started in 1952. Next page, my lord, page 48,
This Gambura was
Gambura
born in
is-
1952.
52,
52.
52, my lord. He
And the
stated,
petitioner was born in
petitioner was born in, my lord, 1975. At Sotola Nonke. My lord, he stated that petitioner's father is older than him, my lord. Gambura. In the page 48, third line, my lord.
Then there's a petitioner one.
the Gambura says, I personally know the opposite.
My lord,
He knows that.
he knows well.
Was he cross-examined?
And
And
He
also
may
stated-
personally know, he may not personally know.
But he was appointed Gambura only in 85, but
Maybe.
he knows the same village.
We are not examining his evidence as a Gambura. We are examining his evidence as an individual
Whether
who
he-
claims that he personally know the family. If you accept your submission in one case, next case will be against you. Then we'll give all the value to the certificate of the Gambura. Depending on which year the Gambura assumed office. So it will be more credible to examine whether the man, whoever he deposes, irrespective of Gambura or any other person, whether he has, he clearly claims that I personally know. মই ব্যক্তিগতভাৱে অপৰপক্ষক, what is that line, Mr. Page 49, মই ব্যক্তিগতভাৱে
মই
বিপৰীত পক্ষৰ ঘৰ,
বিপৰীত পক্ষক সার্টিফিকেট ইস্যু করেছিল।
নাই
বিপৰীত পক্ষ
তাৰপিছতো বিপৰীত পক্ষৰ
দেউতাৰ
ঘৰ,
নাম
It's the boundary of some other village lordship.
বিপরীত পক্ষর দেউতার নাম আলাবক্স,
আলা-
বিপরীত পক্ষর ঘর চতলা ননকে
মই ব্যক্তিগতভাৱে বিপৰীত পক্ষক চিনি পাওঁ।
চিনি পাওঁ।
This is the line. Even if he is a Gambura of somebody else, a man comes and say, I personally know this man.
Lordship can send it back.
I think he has to
Cross-examine.
if he says, I personally know, you cross-examine from where you know. Mere statement personally know is not sufficient. He'll also have to explain how he personally knows. Third, Mr. M. Islam, then counsel for the petitioner also. The petitioner Arfan Ali had been referred to the Foreigners Tribunal number 2 Bongaigaon at Ohayapuri to render an opinion as to whether he is a person who entered the state of Assam from the specified territory on or after 25/3/1971, resulting in registration of case number BNGN/FT/3620/08. The tribunal rendered an opinion dated 3/8/2017 declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ petition, the petitioner relies upon the voters list of 1966 of village Sotola Nongke, police station Bagbor in the present Borpeta district, which contains the name of Allah Box, son of Asraf Ali at serial 52, and that of Ujala Khatun, wife of Allah Box at serial 53, where both are shown to be residing in the same house number 21. Petitioner claims that Allah Box of the 1966 voters list is the father of the petitioner. To substantiate the same, the petitioner relies upon the deposition of DW2 Sarman Ali Talukdar of village Chotola, who is also the Gambura of the village from 26/4/2015. DW2 Sarman Ali Talukdar in his deposition stated that the name of the father of the petitioner is Allah Box and the house of the petitioner is at village Chotola Nongke, and further that he personally know the opposite party, and also that the petitioner Arfan was born at Chotola village. As DW2 had rendered evidence on his claim that he personally know the petitioner, there is also a requirement of the respondents in the Home Department to cross-examine DW2 to extract the veracity of the statement that he personally know the petitioner so as to make his deposition on the basis of personal knowledge. For the purpose, remanded back to the tribunal to allow the Home Department to cross-examine DW2, particularly on his statement that he personally knows the petitioner. In doing so, the DW2 to also state the circumstance under which he personally happens to know the petitioner. Petitioner may also produce any further material if so advised. The Home Department may also make their own verification and submit report. Regional order.
Copy of the order. Lordship.
Copy order to
9 to 11.
Last two paragraphs already be the common paragraph. Yeah. We are regularly passing orders every day. Last two paragraphs of the common paragraph that will be added. So these people surprised, what happened?
Make clear.
Yes,
My lord, this actually three cases.
Alimuddin, who is the father?
My lord, the father is the lordship mechanism page 21.
21.
Is the
Paschim Jamuna Gaon. Did we hear this matter a few days back?
yes, my lord, because one
The
issue is there,
petition
my lord.
instituted in respect of common just,
Three cases, sir, my lord, tied together. My lord.
and today all the three are listed together.
Yes, sir.
I don't remember.
Three references are answered in a common judgment. The tribunal cannot do it because these are all individual.
Different
We set aside the common judgment, send back all the three
and
to enable the tribunal to pass individual opinions on the three references.
that's the approach. Lordship.
That's the only thing we
Yes,
can do.
Lordship.
It is, Mr. Juvenile also.
They're not
It
related.
it is noticed that
Huh? They're not
that
related
this
to each other.
writ petition is instituted being agreed by the common order dated
Plus
But they're
30-10.
44, case
all
44.
related. He says son, mother, daughter.
Still it will be individual.
Let it be case wise because the facts
Case wise,
has to be different.
you
Lordship.
can adopt a few paragraphs. That is a different aspect, but
But the opinion should be
Hmm.
separate in each case, Lordship.
কি করবো? Of a common. Dated 30-10-2017 of the Foreigners Tribunal number 10 Nogao at Hongodev Nagar, Hojai, by which three references being FTD case number 166-2017 in respect of State versus Musammat Tarabanu, semicolon, FTD case number 166-2017 corresponding to State versus Musammat Hajira Begum and FTD case number 1667-2017 corresponding to State versus Muhammad Alimuddin had been rendered. Muhammad Alimuddin, in respect of the common order passed in FTD case number 1667-2017 has instituted this writ petition. We have been told that the other proceedings, namely Musammat Tarabanu and Musammat Hajira Begum, had also instituted their individual writ petitions against the same common order of the tribunal in the aforesaid three references. A reference is made to the tribunal for rendering an opinion as to whether the proceedee is a citizen or whether the proceedee had entered the state of Assam from the specified territory on or after 25/3/1971, or as to whether he is a foreigner. In such proceeding, the proceedee is required to discharge the burden under Section 9 of the Foreigners Act 1946 that he is not a foreigner. As the burden is an individual burden of the respective proceedings, we are of the view that the opinion to be rendered by the tribunal would also have to be an individual opinion in respect of the individual proceedings. Although it can be stated that the proceedings may be from the same family. If the proceedings are from the same family, that would also require an individual conclusion to be arrived at that they are in fact from the same family. From such point of view, we set aside the common order dated 30/10/2017 in FTD case number 1667/2017 in respect of the petitioner Muhammad Alimuddin and remand the matter back to the tribunal to render individual opinion on the said reference instead of passing a common order. এইটো বাকি তিনটাও একেবাৰে দি দিব এইটো তো লাষ্টত আলিমুদ্দিন কলো এটাত হাজিৰা বেগম হ'ব এটাত তাৰা বানু হ'ব কেছ নাম্বাৰটো বেলেগ হ'ব ৰেষ্ট আৰু কিবা বেলেগ হ'ব নেকি ফাৰ্ষ্ট লাইনটো বেলেগ হ'ব নেক্সট ৰিটখনত দ্য পিটিশনাৰ তাৰা বানু হ'ব থাৰ্ড খনত দ্য পিটিশনাৰ হাজিৰা বেগম হেজ বিন সিটিউটেড এগেইনষ্ট দিস কমন অৰ্ডাৰ I think the rest may be same side over, but noise at the tell you. Any confusion you ask me? Huh? No. Things are not say. Common reference in respect of three references, all three names will be there. That will be common for all the three orders. Only thing in the beginning, petitioner it was Alimuddin, there it will be Taravanu, and the third one it will be Hazira. In the end, the FT case number is all corresponding to the name there. And in between, I think will be same. Appearance also same day. Mr. Uddin, same order in all the three petitions. As a considerable delay had occurred because of the aforesaid, the tribunal is requested to render its opinion as early as possible, preferably within a period of 3 months from the date of appearance of the respective proceedings.
Item 12.
May I please, Your Lordship? The petitioner parents' name appear, my lord, in Buddha list 1966,
Page number
page 39, Lordship.
39. Ainal
Yes.
Hussain.
Petitioner father's name Ainal.
Ainal is the father.
And Asiya Khatun is the mother.
Asiya Khatun mother.
And again, their name appear in the Buddha list 70 also.
Moinbari Nongke. Now, which document will show Ainal is the father?
Lordship, only one document, Lordship, the Gavra certificate, page 50. And mother also examining this.
Mother. Where is the mother?
Mother examination, my lord, page 34. Lordship.
30,
34. Lordship.
3, 4.
Now they are residing in the district Goalpara, my lord. After 90 they shifted. Now saying that Zabida is my daughter.
3, 4 is the deposition of Asiya Khatun. Asiya
Asiya
Khatun
is
is
the mother.
somebody different.
Asiya Khatun is the mother.
Asiya Khatun is the mother,
Lordship.
but Asiya Khatun is the wife of Ainal.
Lordship, wife of Ainal. Ainal is my father. And petitioner,
Understand.
behold, Lordship, is the Zabida. Zabida is the petitioner.
Mr. Bhuyan,
Ainal-
Mr. Bhuyan,
Lordship.
we don't want any unsolicited information as you are going on. Please come to page 34.
Lordship.
Asiya Khatun, you claim to be the mother. But she described herself as, my father's name is Habeg. She nowhere states that she is the wife of Ainal. To be the mother of this Jabeda, she has to be the wife of Ainal, so that Jabeda can be shown to be daughter of Ainal. But this Asiya Khatun is, my father's name is Habeg. How do you know?
But here, my lord, last line, Lordship, that my name was enlisted along with my husband in the voter list of 1966.
Very
Last
well.
line.
Who is the husband? No one knows.
Husband, my lord, the page, my lord, 39.
That is a presumption. Provided this
Final.
Asiya and that Asiya is same, only then it is true.
Yes, Lordship.
It is possible that they are the same Asiya, but some material has to be there to show it. Find out. The petitioner relies on the evidence of on the deposition of DW2 Asiya Khatun to establish that she is the daughter of Ainal Hussain of the voters list of 1966 of village Kismat Moinbari Nongke at page 39, where Asia Khatun is shown to be the wife of Ainal. But DW2 describes herself as Asia Khatun, daughter of Habib, without stating that she is the wife of Ainal. Mr. Bhuya, seeks for adjournment to examine the aspect.
Item 13.
Item 13, yes.
Lordship.
13, Mono Mohan Das,
Lordship.
Manbahar Bormon, Manmohan Bormon,
Page Lordship 36.
36.
Total
Mohan Bormon,
Lordship Sosindra Mohan Borman is the
son of
father.
Phatik,
Yes, And-
village Balavita.
Yes, and Basibala Borman is my mother.
Basibala Bormon, mother.
Village, my lord Balavita.
Which document will show
And
that
Lordship page
Sachin
page 37, my lord.
37?
My name appear
Manbahar Bormon, son of Sachin.
as in the same village, my lord, Balavita. Mon Bahar
Batiwala
Borman.
is also there. Mother and petitioner, 97, Balavita.
Basibala. Same village.
That is okay, but who is the proceeding? Manbahar Bormon or somebody else?
Mon Bahar Borman.
Where is the notice?
That is not enclosed, my lord. His
They
name
have it with
also known as Monmohan Das.
This is the
As
difficulty.
LCR receipt, my lord.
So we want to examine the known as factor. To whom the notice was issued?
Lordship, page,
Hmm,
my lord, 18.
Page 18.
Yes, Lordship.
Monomohan Das.
Monomohan Das, son of Sosindra Borman. Father name Borman, my lord. She is also Borman.
No, that's why Manbahar Bormon, Manbahar Das, Manmohan Das, Manbahar Bormon. To whom, who is the proceeding? Manbahar Bormon or Manmohan Das?
Lordship, it says Mono Mohan Das.
That's why I'm asking.
Yes, and here he has 3 aliases.
No, there is nothing called alias. There is actually only one man.
But the
Ah,
petitioner has.
Either that man is Manmohan Das
Das.
or he is Manbahar Bormon. He cannot be both. If the proceeding is Manmohan Das, you have to show with document relating to Manmohan Das. If you are actually Manbahar Bormon and not Manmohan Das, go and tell the tribunal straight away that I am not Manmohan Das. You have wrongly gave this notice to me. I am Manbahar Bormon.
His father's title is Bormon.
That's why.
And my document also saying Borman. So far voter list is concerned.
So you have proved the case of Manbahar Bormon.
Borman.
But are you Manbahar Bormon or even Manmohan Das?
I am not Monmohan Das because notice show.
Where is your statement that you are not Manmohan Das? In the WS, did you take that stand?
Yes.
Because Das can never prove with document that he is Bormon. Bormon can never prove that he is Das.
Lordship.
So if the notice is given to a wrong man or under a wrong name, that's the first thing you should go and tell the tribunal. That you have forced this document notice on me, therefore I am here, but I am not this man.
They accept the notice, they go and contest the matter because the father's name is same.
Understand? So
If had he taken a
the
stand. it would
same
have
problem,
walked
Madam
in his-
Verma, it's repeating again and again. If notice is given to Y in the name of Y, but that man is actually X, he can prove his case only as X. He can never prove as Y.
Lordship, in WS it is written, he is known as Mon Bahar Borman alias Mon Bahan.
Alias, why do you admit your alias?
Mon Bahan.
Who asked you to admit earlier?
Notice is as shown. that.
See, the most simplest straightforward approach is if the notice in the name of another person is served on Monbahar Bormon, he should firstly go and tell the tribunal, see, I am Monbahar Bormon and not this Monmohan Das. First, you correct yourself that whether you want to proceed against Bormon or you want to proceed against Das. Moment the tribunal says we want to proceed against Bormon, Bormon will produce all these documents and show that he is a citizen. If the tribunal says we want to proceed against Das, Bormon is just straight away walk away, tell the tribunal, don't disturb me anymore because I am Bormon, I am not Das. Don't disturb me. And compel the tribunal to record it in its order. Unless this rudimentary thing is done, this confusion will always remain. Bormon can never prove the case of Das. Das can never prove the case of Bormon.
Yes.
It can be,
So we do one thing. Repeatedly, we can't go on consuming everybody's time. We are going to declare that Monbahar Bormon is an Indian citizen. We are satisfied with it. And no authority shall disturb Monbahar Bormon.
As Monmohan Das.
If they want to proceed against any Monmohan Das, you are free to proceed. No? They can proceed against
information-
Monmohan Das. But don't disturb Bormon.
Lordship, I have a submission. The information which is in the inquiry report is given by the proceeding themselves. We do not pick up the names and write the father's name, mother's name. Lordship, will look at page 19.
So therefore,
Maybe he said but he's trying to.
did you
connect
ever
himself.
tell the inquiryman that you are Monmohan Das?
No, Lordship.
Then why did he write? Ask this man.
This is written by the inquiry officer.
He will write whatever name, if somebody asks me what is my name.
But so far
But
my,
I say they will write that, Lordship.
WS is concerned, I have.
How do you move around? You move around with a
Really, Lordship. you
Just-
don't know
just a
the
minute.
Documents.
Just a minute. How do you do an inquiry? With a unfilled form, you move around in the road, get hold of this person. Yes, come here.
Maybe.
What
they-
is your name?
they-
What is your father? Do we do it that way? Or you target a person having doubt about their citizenship, then you approach this person. If
It's
you,
not
just a minute,
Targeting, Lordship.
Madam Verma, there is a reason why you are putting this question. If you do it in a random manner, you don't know at all who the person is. Suppose Mr. Islam is sitting there. I don't know who that Mr. Islam is. I don't know his identity. I find him on the road. I'm the inquiry man. Just call him. Yes, what is your name? What is your father's name? This, that. Now prove your citizenship. If that is the approach, then this name Monmohan Das must have been stated by that man who was asked. Or you approach that against a specific person, you have some doubts whether this man is a foreigner or not. Moment it is specific person, you must have the name of that person with you beforehand. You will at least fill up the form regarding the name of the person, then approach him. And now tell him, yes, Mr. Monmohan Das, tell us the name of your father.
This first.
If you are
letter
doing
was-
it in the first manner, we'll look at it different manner. If you,
No, I'm just going by the date in the inquiry report. It was a IMDT case of 2002.
very well, no, it's getting there. But these small issues, we can't waste so much of time.
I'm-
We have
I
a
think
number of
because-
matters to attend.
No,
So
whatever
simplest,
is before us, we can only submit
Ah,
that. Lordship.
understand. So simplest method we can apply is Mon Bahadur Bormon, we are satisfied that son of so and so, we are satisfied he is a citizen. Don't disturb Mon Bahadur Bormon. On the other hand, if the authorities have any view that Manmohan Das is to be proceeded against, you are free to proceed against Manmohan Das by serving notice on him alone, not on Manmohan Burman.
In 2002, he was 40 years old. Today, he must be very old, Lordship.
Maybe you are protected,
Yes.
but we cannot allow
Lordship.
somebody else's lashes to be the basis to go on proceeding against a person more and more and more and more. It has to come to an end.
Lordship may pass orders.
It's a very
Yes, Lord.
safe order from both the ends.
In case there is a doubt, we'll proceed with the right
In
person.
case the authorities are of the view that there exists a man called Manmohan Das, he has to be proceeded with, liberty to proceed against him by serving only on Das and not to disturb Burman. We'll pass that order.
Lordship may pass it, even I will not be there.
The record says page 61. The notice is issued to Manmohan Das. But number 2 is Duloti Burman, Sundar Kumar Burman, everybody else is Burman.
So
Only thing the main man is Das.
that is why I was going to the inquiry, because all names.
So these
below-
are all botched up inquiry. So we'll clear Burman and give liberty to proceed against us, if at all he exists. Had Mr. K. Burman, sorry, K. Bhuyan and counsel for the petitioner also. It is noticed that an inquiry was conducted against Manmohan. There exists a report of the inquiry officer against Manmohan Das, then aged about 40 years. And the name of the father is shown to be Sachindra Burman. And the other family members are stated to be Duloti Burman, Sundar Kumar Burman, Prem Kumar Burman, Raj Kumar Burman, Amitabh Burman, Mithun Burman, Bidhabala Burman, full stop. Notice was served by the tribunal accordingly on Manmohan Das, stating him to be son of Sachindra Burman of village Balabhita. Although the notice was addressed to Manmohan Das, it was actually served upon. It was received by Bandana Burman, wife of Mithun Burman. Be that as it may, what is that voters list? Mr. Bhaiya, just now you referred.
Page Lordship 35,
Page 35.
65 voter list.
Page 35.
Village my lord Balabija. Father name Sachindra Mohan.
Pursuant to such a notice, Manbahar Burman appeared before the tribunal and discharged the burden under Section 9 of the Foreigners Act 1946 to show that he is not a person who entered the state of Assam from the specified territory on or after 25/3/1971. To discharge the burden, Manbahar Burman produced the voters list of 1965 of village Balabhita, which contains the name of Sachindra Mohan Burman, son of Patik at serial 12, and that of Bansibala Burman, wife of Sachindra at serial 13, where both are residing in the same house number 7. The voters list of 1997 of village Balabhita was also produced, which contains the name of Manbahar Burman, son of Sachindra at serial 48, and that of Bansibala Burman, wife of Sachindra at serial 50, where both are residing in the same house number 12. On the basis of the said two documents, it can be safely said that Monbahar Bormon, son of Sachindra of village Balavita, had discharged the burden that he is a citizen of India. But as because the notice of the tribunal as well as the inquiry report of the inquiring authority reflects the name of Manmohan Das, son of Sachindra Bormon, therefore, the person who appeared before the tribunal, that is Monbahar Bormon, was also declared to be a foreign national. We are unable to accept the said view of the tribunal inasmuch as Monbahar Bormon, son of Sachindra of village Balavita, had discharged the burden that he is a citizen of India. Accordingly, we provide that Monbahar Bormon, son of Sachindra of village Balavita, shall not be treated to be foreigner in any manner, and nor the authorities will disturb him in any manner by considering him to be a foreigner. But on the other hand, if the authorities in the Home Department is of the view that Manmohan Das, son of Sachindra Bormon of village Balavita, if any such person do exist, is required to be proceeded against, the tribunal, the Home Department as well as the tribunal would be at liberty to issue notice to such person alone and not to Manmohan Bormon, son of Sachindra Bormon, or any of his family members, and thereafter proceed against Manmohan Das. But the order of the tribunal is accordingly to be understood that it would not be applicable against Monbahar Bormon, son of Sachindra Bormon of village Balavita.
Lordship, son of Sachindra Bormon may be written as late. Sachindra Bormon, late Sachindra Bormon.
Copy of this order, Lordship.
When the father dies, his existence, previous existence does not cease to exist. So he remains Sachindra Bormon.
Probably saying late, but I love this.
I have a
Copy of the
this.
order there, Mr. Bormon. Yes, I think the microphone may be off. Just please check up.
Lordship. Page in 19, Lordship.
Page 19.
Page 19. Page 19. My father's name is Momrej Khan. And Mona Khatun is my mother. At village Kamalpur. Kamalpur.
Page number 19. Momrez Khan is the father.
Father.
Aimonessa is the mother.
Mother.
66.
Village Kamalpur.
Village is
Village
Kamalpur Palm.
Okay.
Borpeta.
In 1986, Lordship, due to for the better prospect, Krishna shifted to village Manglapara. In page, Lordship, page 26, Lordship.
This is 1997.
Some-
What happened in between?
Sir,
From
in second,
66 to
in-
97?
My name enlisted with my father in draft put a list in 1971.
1970, Momrez is still there in Kamalpur.
Page 24.
What about 1977?
Page 24, Lordship,
24,
1971.
24, what happened?
It is only, Lordship, draft put a list of
1977, it is Kamalpur Palm.
1971.
Then after that, in 1997, it goes to Bangalpara.
Lordship.
And
I shifted 86, in 86, Lordship.
86.
86, 1980.
How do you prove it?
Lordship.
How do you prove it?
Lordship, that is not proof, Lordship, as per Mutal list, Lordship, they are verbally stated that I shifted in
Yes, sir.
1960.
I don't think we have to repeat the same issues, questions again and again in every matter. There is a difference between a statement made and a facts established. What you are doing is making a statement. You have to establish the shifting.
Lordship, in shifting, Lordship.
Produce any material which will show there is shifting. For you, responsibility is over. Yes, I made a statement. But we cannot base our judgment only on a statement of Mr. Suleiman. Our judgment has to be based on materials produced before the court. Petitioner may produce any
stated-
material which may show that.
I state in the paragraph 5 version. I state in paragraph 5.
Take the dictionary and find the meaning of what is the meaning of a word stated. Is it backed by any evidence? No.
No,
Okay.
in the paragraph is the statement that he is shifted from this to this version.
When we are repeatedly requesting you, please establish, you are repeating the same thing again and again, I have stated. We know you have stated. If stating is everything in this world, will it be sufficient? Suppose today you make a state that, yes, I am a doctor. Will you become a doctor?
No, I
Yeah.
have to prove, I have to prove.
You have to establish you are a doctor if you are a doctor. Then that's the difference between stating and establishing it. Please establish. And you are experienced counsel, you are here in this court every day, you are aware of what we want. In spite of that, you repeat it again and again. That I have to repeat also these words to you every day. Why? Then we'll also put a recorded voice recorder somewhere, put it on for you. We don't take the trouble of repeating the same words every day, every case. Moment you say statement, we'll ask the court master to put the voice on. Why should he take the trouble of in every case? Same thing. And I'm very sure you understand also the requirement of law. Petitioner may produce any material which may show that the family of Mamrez Khan, whose name appeared in the voters list of 1960, 1970, and 1977 of village Kamalpur, had later on shifted to village Banglapara, so that the name of Samsul Haq, son of Mamrez Ali, now appears in the voters list of 1997 of village Banglapara. List next week.
Item 15,
Yes,
May I please, the lordship, I require little accommodation for the day.
adjourn on the prayer, the host and counsel for the petition.
Deeply obliged.
16 for orders. Item 16,
You want to implead the other person or you want to proceed with the revision on your own?
Just my submission, if recorded to the extent, that will be okay.
Oh,
The rest part is up
By
to
recording
lordship.
the submission, we will have to write a huge judgment on this. Why should you spend so much of time unnecessarily? If you raise the issue, we'll answer it. And then we'll answer and keep it pending like that for a long time. But if you want to go for the actual hearing on this question of a sanction, hearing, because that is an submission which is expressly unacceptable, that implead the other man in my revision petition. So why should he write a huge judgment on that? Why so much of judicial time should be wasted? Any issue raised, if it is relevant, we definitely will devote a lot of time for that. When it is an irrelevant issue raised, which is expressly unacceptable, why should we give a hearing and pass a judgment on that? It's a public time we are consuming.
Lordship, as Lordship finds it fit for.
Can it ever be conceived that in a criminal matter, a person who is holding a judgment in his favor, which has attained finality, he is the benefit of that, merely because the proposition of law was wrongly appreciated, will now be made a respondent in another similar petition of somebody else?
Lordship, answer is directly no. Not
Uh-huh.
required. Answer
Not directly, no, in every manner it is no.
one submission, Lordship, what I understood to submit, that the moment the single judge, subsequent single judge order has been
Mr.
upheld,
Bhagavati,
Lordship,
we know you are an experienced counsel and we know you deal in criminal law. What is criminal law? Can you ever conceive that that judgment will be impacted by any judgment we deliver in this petition, this proceeding? Never. It can never be impacted. Now, natural justice, although it is foreign to criminal law, except for the limited purpose,
Lordship.
it's a concept of administrative law. Even if he adopt it, hearing is given to a person who may be adversely affected. That man will never be adversely affected because he is already the beneficiary of a judgment which has attained finality. Why should he be heard?
Lordship, moment this division, honorable division bench upholds the subsequent honorable justice finding that his proposition of law is correct, then immediately that the learned magistrate, that is the special judge, who had taken cognizance, will be able
Can
to-
never do it.
again he take cognizance
He can
on the
never.
strength of this honorable.
He can never do it. Because there will be a judgment of the High Court sitting in between.
But when this.
Mr.
Lordship,
Bhagavati, it's unnecessary arguments you are
Lordship,
raising and only wasting time.
Lordship,
Because the judgment which has attained finality can never be moved away by the session judge. So if the final judgment is giving benefit to that man, no notice can be issued to that man, as long as that final judgment is not interfered by some higher court. Never. Nor a judgment can be reviewed in criminal under CRPC. Nor it can be made to be non-existent because of any judgment in any other case, maybe by a larger bench, holding the question of law to be otherwise. You can let your imagination go wild, but you'll never get the answer, I'm telling you. And when we are so firm, means we are sure of ourselves.
so that is the only issue, whether what.
And why you are so bothered about the other man? You
No.
first bother yourself. Either you want to start the hearing today, start. If you don't want, whenever you want. This issue, this is the third day, we are closing it. And we have no inclination to pass any judgment on this issue. When it's a non-issue.
As your lordship decides.
If it's an issue, definitely we'll go into it. It's a non-issue. So a litigant raising a non-issue, there is no requirement of the court to pass a judgment on those non-issues.
As your lordship decides. And lordship. regarding
Because
the-
we don't see any circumstance, even if we hold in a manner otherwise, that beneficiary of that judgment will be impacted in any manner.
Can lordship it be indirectly that learned
There is
special
nothing
magistrate,
called
special
indirect.
judge will be binding by this division bench order? Can he act upon, since division bench says
What is the impact of that judgment? Whatever cognizance had been taken had been set aside.
that was set aside?
Ah,
But yes.
So when the cognizance is set aside, how can the session judge continue with that cognizance?
The moment the.
How,
because
under
the
which
similar
law?
order, because similar order is putting to
We are heading towards imposing cost on this petitioner. You have to buy the time of the court from now onwards.
No, Lordship, that- As
You have to
said-
pay for the
No, just I-
time you are taking of the court.
Lordship,
You have to, from henceforth, you have to pay for the time you want,
no, Lordship,
the
to that,
time of the court you are consuming on this issue.
this issue, I am not buying
Very
any
better
time.
not.
That's for that issue. we are
Because
not
that
so
man
worried.
can never be impacted.
Then it's okay. Lordship.
Only circumstance is if the state goes in appeal against this judgment, and the state can at any time go.
Lordship,
Whether
that is
we
okay.
pass a judgment, we hold it otherwise, we don't it otherwise, they can always go.
Lordship.
Other than that circumstance, that man,
We
that
don't-
cognizance, I don't think you can ever take cognizance of that case, in that case of that man. Your only thing is heart burning. He escaped, I am unable to escape.
As-
Nothing else.
As your Lordship decides, it's okay.
And Article 14 is not applicable. Negative application is not there. He is a lucky person, he got the benefit. So now I will have to bring him back again to the fold because we committed the offense together. You have escaped, I have not. Now he also come and join me. That's not available to you under the law.
That's all.
Hmm. Yes, what is your submission?
Well, also I'll leave it to you, Lordship.
You don't
because the
leave us.
state-
I am-
state- the state
When
has
we
a-
ask your
the-
submission,
the
you have.
state- Yes, that's what I'm submitting. You know. The
You
state
make the
has,
submission.
state hasn't come on appeal against that judgment. So now, before your Lordship, this petition is there. This petition can be decided. That's what-
This one we are deciding.
that's my submission.
Here, there's a possibility we may hold the same view as the beneficiary of that judgment also. That
Lord,
possibility
Yes,
is
there.
there.
What possibility?
It's not ruled out.
They-
That
they-
depends on how you present your matter.
Lordship.
So we are ready today?
Regarding requirement of prosecution sanction. That issue.
If you're ready, you start. If you're not ready, you take a majority.
So only issue left is that whether prosecution sanction is required or not.
I don't know.
When,
On merit, we are yet to hear you. Because the very first day you raised the question of including somebody else.
for this issue, Lordship,
If
that,
you're ready, you start. If you're not ready, you can take a date whenever you want.
We'll do some other time, Lordship. Maybe some other time. Because now this issue is settled. Only thing is remains is that petition.
Not said, we don't want to devote further time for that because it's a non-issue. And we gave you 3 days to produce any proposition of law. Till now, other than oral statements, nothing is produced.
Lordship,
Show us one judgment if it goes in your favor. But that judgment must be relevant, mind you.
Lordship,
Not that you stretch and pull it and do it in such a way that you say that it is applicable in my opinion.
Lordship, I have gone through one judgment, which says that in a 302 trial case, that
Sorry,
necessary principle of necessary justice
In a-
was
in
Lordship.
a group, what group case?
302.
In a 302 case.
302 case.
What
The-
happens in a
so
302 case?
That necessary justice principle has been explained in one paragraph. To that extent, I have gone through one judgment.
And how is it applicable in your case?
No, that was.
Your justice is not violated. You are worried about somebody else's justice.
No, Lordship, this is regarding whether application of necessary justice in a criminal law is sometimes, Lordship has already.
It is applicable in some
Yes,
limited
yes,
manner.
Lordship has, only to that effect, I have gone through one judgment.
And
Regarding the
And
fourth issue, I have. left it.
before going there, let us understand from you, what is natural justice? What is natural justice? Tell us. Yes, what is natural justice? Because it's been argued for 3 days, we'll also have to understand what is natural justice now to make it applicable. What is natural justice?
Sir, in our case, for.
No,
only-
first, our case, their case will come later on. What is natural justice? Because he also brought a judgment that it is applicable in also in criminal trial. Now tell us what is natural justice? Natural justice is nothing like that. Justice that happens in a nature is natural justice. It's nothing like that. It is two definite concrete principles of law, specified and well defined. What are they? In legal concept, natural justice is not that justice that is born from the nature is natural justice. Nothing like that. That will be, that concept of natural justice will be something like that of law of equity. In equity, you can do a lot of aspects. But equity and natural justice is not same. Natural justice is a well-defined term. What are they? How many principles are there of natural justice? Because you are arguing a case on natural justice. Let us understand what a petitioner understands by natural justice. How many principles are there? And what are they called?
Right now, it will be difficult for me.
There are two principles of natural justice. One is called odi alternam partem, and the other Latin name is very difficult to name. But the effect is, no one can be a judge of his own cause. The nemo judex something, something like that. Causa sua. These are the two principles of natural justice. Which one you want to rely on?
So here the other side, the adi alternam partem.
Here the other side. There's nothing called
No,
there here
not-
the other side.
Lordship, Adi.
Odi alternam partem.
Adi alternam partem.
That one you are relying on. Now, whose right is it to get a hearing? Who has a right to get a hearing? Under the concept principle of adi alternam partem, who has a right?
If somebody's right is going to be.
Somebody's right is going to be taken away.
Going to be by upon us.
Now, in this case, whose right will be taken away?
Then,
No, just one straight answer. Whose right will be taken away in this?
the earlier petitioner,
Which right will be taken away?
that if the subsequent honorable single judge,
Suppose we take a contrary view, which right of his will be taken away?
if first honorable single judge judgment is not touched, he will not be, petitioner will not be affected.
How can we touch that judgment?
The moment.
Mr. Bhagavati, you know everything, you are just
really
playing with the court and nothing else. This
That's what I
petitioner
mean.
for the last 3 days have been playing with this court. You want to avoid or delay
Not that I
as
lazy.
far as possible from the court from going into the main issue.
I quit it. I have to quit it.
Now
That's
tell us, we want straight answers, but in 1 or 2 words, not those elaborate round and round and round. Which right of that man will be violated? He has only one legal right. He is the beneficiary of a judgment in his favor. Can we, under any circumstance, take away that right? No.
Directly no.
Again, you are using,
Lordship,
forget
no,
about
I-
direct. What is the meaning difference of direct and indirect? Either it is taken away or it is not taken away. There is no direct and indirect. Can we take away that right under any circumstance? No. When it cannot take away that right, no right of that man will be violated. So therefore, odi alteram partem is not applicable in respect of that man. And you cannot explain it in a more simpler term than this. The petitioners, okay, we are putting it in the judicial form. You go and appeal if you want. The petitioners have raised an issue. That the petitioner of Criminal Revision 4/2019, comma, who is a beneficiary of a judgment dated what is the date of that judgment? Judgment
Date of 17/9/2019.
17/9/2019.
19.
Who is the beneficiary of a judgment that is in his favor. কি বলবো sentence to start করলে the present petitioner, দুইটা petitioner হল নয়, the present petitioner has raised an issue that the petitioner of so and so would also be a necessary party in this revision proceeding and therefore ought to be implemented as a respondent. Criminal Revision 4/2019 was against an order dated 3/5/2019 of the Special Judge PC Act in ACB PS case number 4/2017. By the order of 3/5/2019 of the Special Judge in ACB PS case number 4/2017, comma, cognizance had been taken in respect of the petitioner in revision petition 4/2019 as well as against the petitioner in the present petition WPCRL 22/2021, where both the petitions are against the same order impugned dated 3/5/2019 of the Special Judge PC Act in ACB PS case number 4/2017. When WP Criminal 2021 corresponding to WP Criminal 2/2019 before the Isol bench, comma, the learned single judge by the order dated 31/8/2021 had disagreed with the formulations, legal formulations made in the order dated, it was a of Criminal Revision 4/2019.
17/9/2019.
17/9/2019. And accordingly, required the legal issue, legal propositions to be decided by a larger bench. Accordingly, WP Criminal 2022/2021 WP Criminal 2/2019 is being listed for its consideration on the question referred to the larger bench before this court. In the aforesaid circumstance, the petitioners in WP Criminal 22/2021 has raised the issue that the petitioner of Criminal Revision 4/2019 is also a necessary party and ought to be impleaded as a respondent, inasmuch as if the larger bench takes a different view on the legal proposition, the petitioner of Criminal Revision 4/2019 would be adversely affected. Accordingly, the plea of natural justice has been raised that the natural justice requires that the petitioner of Criminal Revision 4/2019 is to be impleaded as a respondent. As a plea of natural justice has been raised, we put a question to the learned counsel to the petitioner in WP Criminal 2022/2021 as to which of the two principles of natural justice would be violated, and it is stated that the principle of ad alteram partem would be violated. In furtherance of this submission, the Land Council for the petitioner submits that the principles of natural justice, principle of ad alteram partem would be applicable in as much as if the decision of the larger bench is contrary to the decision of the learned single judge in Criminal Revision 4/2019, the legal right of the petitioner therein would be violated. We again ask the question as to which legal right of the petitioner would be violated. No answer is forthcoming. Except for a reiteration that his right would be violated. As we understand, the judgment dated so and so in Criminal Revision 4/2019 has attained its finality till any such appeal is preferred by the state authorities against the same. And the petitioner therein is a beneficiary of the judgment rendered therein. Even if the proposition of law is decided otherwise in the present proceeding, the said judgment which has attained its finality would not be impacted in any manner. And as the judgment would not be impacted, the legal right accrued to the petitioner in Criminal Revision 4/2019 would also not be affected in any manner. If the legal right of the petitioner in Civil Revision 4/2019 is not affected, we see no reason as to how the principles of natural justice should be violated. Moreover, we take note of that the issue has been raised not by the petitioner in Criminal Petition 4/2019 that his right would be violated, but it is by the petitioner in WP Criminal 22/2021 seeking to expose the cause of the petitioner in Criminal Revision 4/2019. From such point of view, the issue of raised by the petitioner in WP Criminal 22/2021 that the petitioner of Criminal Revision 4/2019 is required to be impleaded as a respondent in the present revision petition cannot be accepted under the law. Furthermore, when we examine the implication of the petitioner in Criminal Revision 4/2019 being impleaded in the present petition, it would mean that a person who is the beneficiary of a judgment in his favor is now being made a respondent in a proceeding initiated by another person, which again would be impermissible in law. inasmuch as the implication thereof would be that if the decision in the WP Criminal 2022 is different from that of the decision in Criminal Revision 4 for 2019, comma, once the petitioner of the said revision is implemented, this present judgment will also be binding upon him, meaning thereby that the person would now be beneficiary of one judgment which had attained finality in his favor and would be impacted by another judgment in another proceeding on the same issue, which again would be an inconsistent situation and unacceptable in law. For all the aforesaid reason, the plea of the writ petitioner to implead the petitioner also stands rejected. Now, furthermore, if the petitioner in revision petition 419 is impleaded for any purpose and the decision happens to be against him, impliedly it would mean that in WP Criminal 22/2021, the judgment dated so and so in Criminal Revision Petition 4/2019 would have the effect of being reviewed. Under the CRPC, no provision for review is available, either directly or indirectly. And from such point of view also, the petitioner of Criminal Revision so and so cannot be impleaded as a respondent in the present proceeding. Now start on merit on your sanction. For raising a non-issue, a cost of 50,000 is imposed on the petitioner. Which required the court to hear the matter on 3 different dates. Was prepaid to the legal services authority.
Today itself,
Sorry,
today itself, there are 2 points.
payment of the cost today. Say yes,
No,
you
no,
can
no.
pay today itself.
No,
The cost is imposed in a words that on the very first day of the argument, the petitioner was asked to produce any relevant proposition of law which may warrant impleading the petitioner in criminal so and so as a respondent in the present proceeding. But other than oral submissions, no such proposition was placed. But the same argument had been reiterated for the next 2 days at the expense of judicial time of the court. Now we want to, if you want to start, we are ready to hear it today on the actual issue. And mind you, on the second year, we have pointed out that this issue had already been settled by the Supreme Court also earlier. Possibly in that 2006 BSNL matter. Just check out. Somebody raised the same issue there. No, it cannot be done. So indicated earlier, if you are abandoning, we are not, but if you are inviting a judgment from us, it will entail a cost also. And we have already spent enough time to deliver a judgment on that issue.
it is cost,
Sorry,
but
cost is always costly. Cost can never be
We tried. That
But
was-
you took 3 days of the court's time, mind you, so many people are sitting behind for their matters to be taken up. And the very first day we indicated that it is not the law. We are requested you to produce any proposition of law if available in your support. Suppose we are having a wrong view also, correct it by producing a proposition. Other than oral submissions, nothing is forthcoming. Only putting questions to the court that everybody knows about it. At least we did not know about any such law. Even if others know. That a beneficiary of another judgment can be brought as a respondent in another proceeding. No, sir.
Issues are referred in this letter. First, it is requirement of section when the person committing the offense.
All right, Mark, it is better, I see.
Massage.
What is the core issue that whether sanction is required or not?
Required or not, when
And here cognizance was taken without there being sanction.
lordship,
You are agreed by that order.
we are agreed.
And in that other criminal revision,
That is
court held that sanction is required and therefore interfered with the cognizance.
it is the view of the learned single judge.
Single judge,
But
so
for
interfered with the cognizance with a view that the sanction is required.
required
The other learned single judge took the view, differed with that view,
that prosecution sanction is not required.
not required. Now, what is your submission? Not required or required?
So here. And special judge has relied on Supreme Court judgment 2016-9 SCC 598 L Narayana Swamy. State of Karnataka.
Yes, sir, we had noticed it, huh? L.
That
Narayana
judgment,
Swamy.
the learned special judge relied. And in that judgment, it is said that when the person
No, special judge relied on
is L Narayana Swamy.
L. Narayana Swamy and
We
then
say-
held that sanction is required.
Sanction is
Not
Not
required, not required.
special for special judge sanction is not required. And accordingly, he took cognizance by aggrieved.
Okay, sanction not required, he took cognizance, fine, huh?
So
Then,
learned special judge took the view of the Honorable Supreme Court in L Narayana Swamy, which says when the person committing offense at the time of commission of the offense, he is holding some other post, and when cognizance is taken, that person, if he holds some another post, then prosecution sanction protection will not be given to him. That is the
will
law
not be, is not required then.
as per that Supreme Court judgment, that is prosecution sanction not required.
Huh.
If-
So a man will commit an offense,
Today,
the stage will go to the investigation trial.
Lordship.
If he manages somebody to transfer him from one post to another post, he escapes.
Yes, yes, that is very important part. That can be done sometime.
That is Narayana Swamy.
That is Narayana Swamy judgment.
So who followed Narayana Swamy? Learned single judge
Learned single judge
followed Narayana Swamy.
followed.
Then let us look at that order. Narayana Swamy, yes, sir. Yes, sir. এইটো আপুনি এইটো অৰ্ডাৰতে আদাৰ ইছ্যুজ নাপায় কাৰণ এইটোতো এনেও আজি শেষ নহয় সেইটো লাষ্টত পিছত কৰিব চাৰিফালে Which paragraph? Narayana Swami, Pashi, Narayana Swami.
Very good. But in L Narasamy, it is paragraph 12,
L Narayana Swami, paragraph
Paragraph
12.
Which is also referred by the single judge also
Hmm.
in protection.
So,
In
learned single judge in criminal revision 4 had accepted, followed this proposition,
He discussed,
and
Dis-
then held that
held that no prosecution sanction will be required.
sanction will be required.
Required for the first single judge, honorable single judge. First for the revision petitioner, who is not in this case.
And special judge held that sanction is not required.
For space, yes, lordship,
Special judge held sanction not required.
not required and. who
Single
is
judge
con-
held sanction is required
Required.
by following the
Yes.
Narayana Swami.
As sanction was not there, it was set aside
Okay,
for him.
Paragraph 12.
Paragraph 12 of the Narayana Swami.
As it is clear from the plain language of the subsection.
Will to refer this. Oh, order here, no? Oh, sorry. In LR.
Yes, para 12 we have read,
The para 12 probably not correct. I am just giving.
not correct.
Para 12 is not correct. Some
Then
other
which
correct.
is the correct one?
That's why I am checking it. Whereas lordship, it will be
21.
21. Lordship.
21 and
21.
How does para 21 help you?
Lordship, here,
No,
regarding-
let us read the order of the learned single judge in revision. Single judge in revision, revision 4.
revision for-
Here in which page do I get it? Yes, Mr. Quilter, where do I get that judgment of the learned single judge in revision 4?
That paper is not with me.
Then how do you read it then if it is not here?
I mean, I have the paper book of the other WPC criminal. The reference paper book is not with me.
No, no. We have to understand the submission, so we have to read the judgment. Where is the judgment? Which page number?
Reference to the
Here, maybe.
different file.
In a different
In
file.
the record in a different file, it is there.
Some IA is there. Criminal 2022 is there. Where about criminal revision 4 of 19?
One separate file, when I checked the record, I found it.
How was it? Logot?
Has a file.
It is.
Lordship, in separate file, it is not there. Lordship,
Like-
I am having one copy.
Pale nahi. Or IA.
It is there.
IA kune file was state of Mizoram. Yes, in this judgment, how did the learned single judge deal with para 21 of L. Narayana?
In paragraph 5, he referred.
Paragraph
Paragraph 5 is on
Five.
it. Then
Apex Court
Uh,
para 12
para 8.
held that the High Court was right in relying upon judgment of Prakash Patil and so to hold both appeals had abused different and was therefore there no necessity of sanction.
Para 8 is more clear.
Where public servant where they was holding, but it ceased to where the allegation. Coming to the validity, you see that the allegation is traced back to the time when the petition was posted as deputy commissioner. Yes,
Para 12. Lordship.
read para 12 and
Para
para
12.
13 of the learned single judge. It
Para
is self conflicting.
Para 12. The apex court in so and so, the High Court was right. That
No, first you read para 23 of L. Narayan.
para 23.
No, sorry, para 21 of L. Narayan.
Yes.
If the public servant had abused entirely different office or offices than the one which he was holding on the date when cognizance was taken, there was no necessity of sanction. Fine.
There's a problem.
If you're holding a different post, there is no necessity of sanction.
Lordship.
Then again, or was holding a different office, then sanction would not be necessary. Likewise, where the alleged misconduct is in some different capacity than the one which is held at the time of taking cognizance, there will be no necessity of sanction.
Lordship.
That means if X was holding a post
Lordship.
when the
Offense was committed.
act was committed, and when cognizance taken, he was holding B post, then sanction is not
required.
necessary.
Not required.
This is also reflected in para 12 of the judgment of the learned single judge.
Single judge.
Now read 13.
13.
Coming to the present case, it may be seen that the allegation of misappropriation is traced back to the time when the petitioner was posted as Deputy Commissioner Champai, wherein he was also chairman so and so. Since then, petitioner has been transferred and presently posted Secretary Government of Mizoram. Therefore, I find the learned special judge could not have issued process against without there being a prosecution sanction. When para 12 learned court single judge also understood sanction not required. Para 21, L. Chandra Narayan also says sanction not required.
The post is different.
But the conclusion is, could not have issued without there being prosecution sanction, is in conflict with his own paragraph 12, as well as para 21 of L. Narayana Swami. So the other learned single judge had rightly differed.
But two different facts. Facts are appreciated in different manner.
We are
Because-
on law. We are not on fact.
That is the issue. Right this moment, whether I am holding different posts, this is a fact. According to this fact, this law question will come into force.
Are you holding a different post?
I'm in my case, what happened?
Are you just straight answer? See, Mr. Bhagavati,
I am superintending engineer.
Mr. Bhagavati, roundabout answers will never satisfy the court. Only it will consume time. We are going to come back and back again with the same question. Is the petitioner holding the same post or he is not holding the same post?
Not holding the same post.
He is not holding the same
Means
post.
superintendent, I was at the time of offense, I was superintending engineer in PhD of a different circle. And when cognizance was taken, I was in the same post, superintending engineer, that is correct. But in PhD department, that is correct, but in a different circle.
So therefore,
my-
therefore, as per para 21 of Narayana Swami, sanction is not required.
To that effect, sanction is not required.
If sanction is not required, the cognizance taken by the special judge is right.
Right, correct.
So we hold it accordingly. Now you face the trial.
Because now learned single judge from which the issue has referred to this division bench, honorable division bench, to decide this issue. One is prosecution, requirement of prosecution sanction.
No, there is no
And-
requirement.
And
If we
rest part is
follow,
pending.
if we follow para 21 of Narayana Swami, when this person is admittedly holding a different post than the post he was holding when the act was performed, sanction is not required. So one question is answered that way. Second question, whether relevant or not. If not relevant, we may not answer it
It's
also.
not relevant. It is. The only thing is that
So the
sanction is
que-
required and
Interlocutory and final order.
and
So you come back on Monday if you have something more to say.
Narayan Swami squarely covers the issue.
Narayan Swami was rightly appreciated but wrongly applied
Yes.
by the learned single judge.
That is.
For some reason, maybe an error in judgment at the relevant point, something happened.
Lordship.
But the law is correctly appreciated.
Law is correctly
So
applied.
other,
Now,
and the other learned single judge has rightly
Appreciate.
appreciated, also rightly applied.
Applied.
So therefore, he came to a different conclusion. And that has to be answered from our side also.
Lordship, that too is.
If we have to submit something more, Monday, let's for further hearing on Monday. He to tell away. He to tell koi dibo. My area
Lordship, may I submit one?
on Monday, not today.
Uh,
Monday, we have a different bench
No,
now.
not on that merit. Regarding today's order, may I pray, considering all the academic discussions and all.
No,
can the
we are
cost
not
be-
interested
Lordship,
here
can
for
the
any
cost be-
academic decision. Academic decision, you can go
because-
to
because
the
That issue was
Mr.
raised by.
Bhagavati. You can
Lordship.
make an application to the Judicial Academy. There we'll have academic discussions, not here. Here
Lordship,
we are
because-
hard pressed with time. So many people are waiting for their matters to be decided. We have to be
Because
very
that question,
circumspect
Lordship,
how
just-
we spend our time, how we use our time, in fact.
That question was just simply, without entering into the merit, that question, whether he's
But you,
like that.
on the very
and
first
given us
day,
the opportunity, we tried.
Mr. Bhagavati, on the very first day, to be fair to you, we pointed out to you that please look into these aspects. But without even bothering to look in a most, I won't use any expression, in a particular manner, you go on insisting and also tell the court that everybody knows this law. As if we did not know it, everybody knows. In that circumstance, we specifically asked you produce one proposition in your support. Reply given is thousands of judgments are there. And we said produce at least one out of the 1,000. It never came. But the same thing is reiterated for 3 days on a non-issue. That's a wastage of judicial time. Therefore, we have imposed the cost, not for any other purpose.
That is not fair, Lordship, as Lordship says.
Because had it not been done that way, this proceeding would have been over that day itself. The time we consumed for the 2nd day and the 3rd day could have been devoted for some other learned counsel for their matter, who are all waiting behind you. Have you understood? Okay, we'll reduce the cost, but cost has to be there.
Whatever, Lordship.
That much we can do. Instead of 50,000, we can bring it down, but these are corruption cases. 50,000 is no cost, in fact. In fact, the man will be thinking it's peanuts. That much we can do, but this has to be there. And we repeatedly requested you, mind you, to produce one judgment. We may be wrong in appreciating the circumstance. But other than that, it was only shot back at us that everybody knows this law. There are thousands of judgments. We say produce at least one. Until today, that judgment has not come, mind you, after the 3rd day of hearing also. I think you were there present. I don't know. Only Maneka Gandhi was referred. Somebody said Maneka Gandhi's case. But Maneka Gandhi also, which paragraph, which nothing is there. And how irrelevant that is also not there. So therefore, Mr. Bhavati, for non-issues, why should we allow 3 days of judicial time to be wasted? And when we put questions, we seriously put questions. So that a proper adjudication can be made. Just on a good presentation, a judgment cannot be passed if it is contrary to law. What would have happened had I agreed with your thing on the very first day? Yes, thousands of judgments are there. Everybody knows the law. So let me also understand. I also know the law. Implead this man. What would have happened? Just think about the consequence. What would have happened then? What do you say? There's a reason of imposing the cost, not that it is arbitrary, it is imposed. Want it reduced? That we can do. But the token cost also has to be there. Getting.
There is law, there is left.
No, up to
For your
you.
Lordship. Whatever is.
Think reasonably. Think reasonably. Time for the other bench, I think 3:15 is the other bench. Right? Monday. Rest of the matters, Monday or Tuesday, whatever. What to do? Firstly, it's simply indicated that this may be the consequence.
Item 1, 2, 3 for admission.
Controversy, no controversy, difference of views. No, you refer to one particular rule. By interpreting the rule, you say it is 80%. They refer to another rule, which is something different. So now we have to decide which of the two rules will be applicable.
I think on 25/4/23, madam.
The lordship may see the second page, my lord, that's the relevant part.
Final. As per the final zoning regulation, it will be 80%. Which one is in your favor?
2000, madam.
2000 is in your favor,
Yes,
and board relies on 14.
14.
Statement. Forward for reason, wrong reason. Just take this one. Have you seen it?
No. Lord, possibly the issues have been set at rest. The lordship has seen
But
regarding,
2000 will continue in spite of 14,
my lord.
and for FAR coverage, setback, parking, provisions of existing building rules, bylaws are followed. That means 14.
That is 14. That's the position of law, my lord. I'll take your lordships to a appeals court judgment also.
Which one? Sorry,
2014,
14.
yes.
So whatever is provided for setback, etc. in 14 will follow that.
That means, my lord, partly a building regulation is still holding the up to 1000. They say during implementation of the master plan, the regulation up to 8.6 of the said zoning regulations are followed. Regarding regulations related to parameters of the building construction, such as FAR, coverage, setback, building height, size of plot, parking norms, penalty, provisions of the existing building bylaws are followed.
My lord, I think this is reached its finality. My lord, to buttress this submission, I'll place a judgment before your lordship, reported in 2006-7 SCC 714. My lord, I rely on paragraph 13 and 14, my lord. My lord, I'll read
Paragraph 13 and
Para
14.
13 and 14, my lord. When principles of statutory interest, has your lordship got it? My lord? Para 13, my lord. In principles of statutory interpretation by Justice so and so, when an earlier act or certain of its provisions are incorporated by reference into a latter act, the provisions so incorporated become part and parcel of the latter act, as if
they had been boldly transposed into it. The effect of an incorporation is admirably stated by Lord so-and-so. If a subsequent act brings into itself by reference some of the clauses of a former act, the legal effect of that, as has often been held, is to write those sections into the new act as if they had been actually written in it with the pen or printed in it. The result is to constitute the latter act along with the incorporated provisions of the earlier act, an independent legislation which is not modified or repealed by modification or repeal of the earlier act. Now, my lord, para 14 is, it has been quoted from a judgment. Snare reference.
My lord,
নাই নাই কত না ফিলিং কেউ না থাকবে না মডিফাই করবে খালি অ্যামেন্ডমেন্ট মডিফিকেশন করবে
Yes, sir. I think you were continuing. Yes.
My lord, the para 13 is the main paragraph.
Hmm.
My lord, 14 is the reiteration of a judgment of 3 judges benchman.
Hmm.
So it's all the same, my lord. Whatever
So
stated.
this is legislation by incorporation.
So that's all that's my submission. So far that, my lord, your lordship has seen, even the government has clarified their stand. They have said that although, my lord, this will continue, but then in regard to, it will follow up to 8.6 of the said regulation.
Hmm.
And so far.
Yes.
So far, my lord, regulation related to parameters of building construction, FAR cover is all these things are covered by the 2014 rules. Obviously, because, my lord, the no objection certificate, that is the construction permission was taken way back in 2017. Therefore, my lord, there is no reason why the authority will follow the earlier 2000 regulation. So it is regulated by 2014 only. That's my submission.
Yes.
The decision which has been cited by my friends. It pertains to, my lord, legislation by incorporation.
Incorporation.
That is not the case. My lord, I was only wondering one thing, my lord. Can a government later determine which provision will apply, which provision will not apply? In the absence of.
You are open to argue on that. You are open to argue on the correctness of it.
Yes. My lord, can I pray one thing, my lord? I am not prepared with it because I didn't know that it should be the. Can you also give me half an hour time at 3:30 on any particular day, my lord? I cite 2-3 judgments on this point. Because to be honest, my lord, I am not prepared with the case of it. At the end of the day, my lord, in such a situation, let us see whether Supreme Court decisions, what does it see? But prima
According to
facie-
you, the principle of legislation by incorporation is not applicable in this case. And whatever
no
view
case
the
available.
director had expressed in that letter,
Yes.
that requires a scrutiny under the law, whether it is.
Whether there
Right
is a
or wrong.
logical stand, whether such a
Yes.
stand is enabling.
Okay, we'll hear you.
Also, will kindly give me half an hour time on a particular day, my lord. When is the lordship, 3:30?
Package নালাগে দিয়া কাৰণ সিখনেও আৰু বহুত টাইম লৈ লয় এইটো
I will just compiling this one. My lordship will have to take the.
একেদিনে নালাগে নেকি কাৰণ একেদিনে হলে কি হ'ব that bench will consume some time, regular bench will be there plus this one. So let us have some other day. 13 June.
Oh, yes.
How much time will you need? Whole of the second half?
No, well, half an hour. My lord, I'll not
I
take
think
long.
that there
I'll
has
come.
to some reply may also
Then
be
1
given.
hour for both of us. 3 o'clock also it will do.
13 June Tuesday. Thursday, 15 June. Thursday, 15 June. Thursday, 15 June.
My lord.
15. Published.
Lordship wanted to say something.
No, I was confiding with my elder brother that fixation of dates is the prerogative of the presiding judge.
No, it's a prerogative. Everyone. We are here from every day from 10:30 to 4:30. Doesn't matter.
So it's a very interesting point, my lord. In such a situation, how does law operate?
As required by the order of 25/4/2023, the state authorities in the Housing and Urban Affairs Department has produced a communication dated 17/5/2023 from the Director, Town and Country Planning, Assam, to the Additional Secretary to the Government of Assam in the Department of Housing and Urban Affairs, which provides as extracted. A reading of the aforeextracted portion of the communication of the director makes it discernible that although the Uniform Zoning Regulations 2000 is operational even after publication of the Assam Notified Urban Areas bracket other than Guwahati Building Rules 2014, comma, but regarding regulations related to parameters of building construction such as FAR, comma, coverage, comma, setback, comma, building height, comma, size of plot, comma, parking norms, comma, penalty, etc. The provisions of the existing building rules stroke bylaws are followed, meaning thereby that the rules of 2014. To substantiate the veracity of the aforesaid stand of the director, Mr. S. Dotol and City Council for the Silchar Municipal Board has referred to the judgment of the Supreme Court rendered in SNE Enterprises versus the Commissioner of Customs, New Delhi, reported in 2006, 7 STC 714, wherein the principle of legislation by incorporation had been discussed in paragraph 13 and 14. Mr. Ken Chaudhary, Learned Senior Counsel for the petitioner, has raised the contention that the principles of legislation by incorporation would not be applicable in respect of the contents of the aforeextracted paragraph of the letter of the director. And further, that the veracity of the aforeextracted paragraph would also have to be examined. For the purpose, an adjournment is sought for. Adjournment allowed, list on suits. Much. A copy of the hearing is kept on record of the communication.